We will start our day, and I wanted to welcome. We have several substitutes. We have Lisa Mazer substituting for Representative Morse. We have Representative Vanessa Sheehan substituting for Representative Dry, and Representative Edgar substituting for Representative Selig. So welcome all. I hope you enjoy your time in education policy. We have a lot of fun here. So let's start out with the pledge, if we might. Representative Litchfield, would you lead us?
Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. We have a number of bills to vote on this morning, and we'll get started right away with how about HB 662? You can take the gavel. Which is requiring the discussion of abortion procedures and viewing of certain videos during health education in public schools. Madam Vice Chair?
We're going to open the executive session on HB 662, and I recognize Representative Cordelli for a motion.
I would move ITL on House Bill 662.
Is there a second?
I'll second that.
Representative Freeman, Representative Cordelli, discussion?
Yes, thank you. I think that this bill goes a little bit too far in terms of naming specific videos, requiring that 2 out of the 3 named videos be shown each year in high school. I think that's a little bit much. I don't have a problem with showing videos on abortion itself, but naming specific videos and requiring each year in high school, I think, goes too far. Plus, the fact that it gets the Attorney General's office involved in monitoring the viewing and possibly prosecuting if videos aren't shown. I think I would hope maybe the Attorney General's office has some better things to do with their time. So for that reason, I move ITL.
Any discussion from the second?
No, thank you, Madam Chair. I would absolutely 1,000% agree with Representative Cordelli on why this bill should be ITL'd. While I do appreciate the sentiment of it, I think there's just too many hoops to jump through and too many hurdles, and the meaning of the bill would definitely get lost with some of the minutia. So I agree with Representative Cordelli.
Right. And I appreciate the 1,000% agreeing with me. Thank you.
It's not going to happen again.
Any other discussion? Representative Woodcock.
Thank you, Madam Chair. I'd just like to comment on the bill as well. I'm appreciative of the fact that I believe our health and wellness teachers in our public schools do a hell of a job, and we don't need to legislate from here what particular curriculum they use. Thank you.
Any other discussion? Seeing none. Madam Clerk?
Vice Chair. And me last.
May I just clarify, Representative, is it Mazer? Sorry. Thought I did so good. Okay. All right. So this is on bill number 662. The motion is ITL. Representative Noble,
Yes.
Representative Terry,
Yes.
Representative Sheehan,
Yes.
Representative Freeman,
Yes.
Representative Litchfield is yes. Representative McDonald,
Yes.
Representative Tenzar,
Yes.
Representative Mazer,
Yes.
Representative Nato,
Yes.
Representative Cornell,
Yes.
Representative Murray,
Yes.
Representative Woodcock,
Yes.
Representative Hall,
Yes.
Representative Balboni,
Yes.
Representative Edgar,
Aye.
Representative Kluger,
Yes.
Representative Snodgrass,
Yes.
and Chairman Cordelli.
Yes.
Okay. 18-0.
Consent, no objections? Great, thank you.
Do you, while I have the gavel, do you want to go to, HCR 6?
Yep.
We're gonna open the executive session on HCR 6. And I recognize Representative Cordelli for a motion.
Thank you very much. This is
HCR
HCR 6, which was the removal,
Removing superintendent.
resolution for removal of the superintendent of District 67. Right. And I would move ITL on HCR 6.
Is there a second? Representative Hall seconds. Any discussion from the maker of the motion?
Thank you very much. I'm just looking for the bill, but yeah, I understand the sentiment of the prime sponsor in this case that involved no trespass orders being handed out to several parents at a girls' soccer game in which they were wearing pink wristbands with XX on them to show their support for girls' sports. This case is in the courts right now. I think it would be, in my opinion, bad precedent for us to start calling for the removal of educators who we don't agree with on a certain incident or subject area. So I think that we're better off ITLing this and leaving it to the courts.
Any discussion from the second?
Thank you.
Sure.
And yeah, I can't say that I understand the sentiment as much as you do, but I think that was an inappropriate resolution. It targeted an individual. It's in the courts. I'm glad that we're taking care of it now because I think we've drawn it out long enough. And ITL is clearly the appropriate motion for this.
Any other discussion? Seeing none, Madam Clerk?
So the motion is ITL on HCR 6. Representative Noble,
Yes.
Representative Terry,
Yes.
Representative Sheehan,
Yes.
Representative Freeman,
Yes.
Representative Litchfield, yes. Representative McDonald,
Yes.
Representative Tenzar,
Yes.
Representative Mazer,
Yes.
Representative Nato,
Yes.
Representative Cornell,
Yes.
Representative Murray,
Yes.
Representative Woodcock,
Yes.
Representative Hall,
Yes.
Representative Balboni,
Yes.
Representative Edgar,
Aye.
Representative Kluger,
Yes.
and Representative Snodgrass.
Yes.
18-0.
I think I can hand the gavel back now.
Thank you very much.
Do we clarify consent?
Yes.
Yes, consent? Yep. So next we will take up HR 9, which is urging the Department of Education to emphasize STEM education. And I call on Representative Freeman for a motion.
Thank you, Mr. Chair. Mr. Chair, I would make the motion of ought to pass.
Thank you. Is there a second? Representative Terry. Representative Freeman, would you like to speak to your motion?
Briefly, while, House resolutions don't carry as much weight as a bill would, I do think that this would send a very clear message to everyone that we are really looking forward instead of backwards when it comes to the education of our children. I really think this is probably one of the most nonpartisan House resolutions we'll ever see. We all agree that going forward in the 21st century, this is one of the emphasis we need on education. So with that, I would ask everyone on this committee to support the ought to pass.
Thank you. Further discussion? Representative Terry, did you want to comment?
I just want to add that having family members who are involved in teaching STEM courses in another state, the name of which I will not mention here for obvious reasons, very, very supportive of STEM. And so I'm really delighted to see this resolution. I think it's very timely.
Yes, Representative Cornell.
I just want to say, I think the students that testified at the hearing were wonderful in putting their case across of why it's so important to have STEM education. And I just wish it could be STEAM so that we could add the arts into it too. But that's a bill further down the line, I think. But they were coming from a school that emphasizes STEM. So I could see that. But it would be nice to do STEAM too. I think it's great.
Representative Woodcock.
Thank you. I don't want to be repetitive. Actually, Representative Cornell and Perry caught my attention. Almost exactly the same. It was amazing to see those youngsters come, particularly in that big hall, Representative Cordelli, not knowing what was going to happen. They did a heck of a job. I also have a family member who's involved in STEAM, that runs a STEAM festival in San Diego annually, and I'll be visiting it next week.
Great. Enjoy San Diego and some warmer weather. Any further discussion on this bill? Seeing none, Madam Clerk, whenever you're ready.
Thank you. This vote is on House Resolution 9, ought to pass. Representative Noble,
Yes.
Representative Terry,
Yes.
Representative Sheehan,
Yes.
Representative Freeman,
Yes.
Representative Litchfield is yes. Representative McDonald,
Yes.
Representative Tenzar,
Yes.
Representative Mazer,
Yes.
Representative Nato,
Yes.
Representative Cornell,
Yes.
Representative Murray,
Enthusiastically, yes.
Representative Woodcock,
Absolutely.
Representative Hall,
Yes.
Representative Balboni,
Yes.
Representative Edgar,
Aye.
Representative Kluger,
Yes.
and Representative Snodgrass.
Yes.
So, excuse me, and Chairman Cordelli.
Thank you. Yes.
Consent, Chairman.
Yes. That's 18-0.
Yes, sir.
Consent, okay? Yep. Great. Thank you. Next, we will take up House Bill 440 relative to educator licensing. And Representative Freeman, did you have a motion for this bill?
Thank you, Mr. Chair. I do have a motion. I have a motion of ought to pass.
Thank you. Is there a second? Representative Terry. Representative Freeman, did you want to comment on your motion?
Thank you. Thank you, Mr. Chair. Briefly, I do believe that this is a pivotal bill for us at this. We're really experiencing a shortage of career and technical instructors. And seeing as the CTE instructors don't teach any core curriculum, but instruct on their career or technical path, I do believe this would address some of the shortages we're seeing in the CTE programs and really allow all our students an opportunity to receive a career path that they may have chosen.
Okay. We'll hold off for a moment. We had a motion and a second, correct?
Yes,
On
sir.
that of ought to pass.
Yes, sir.
I understand there is an amendment that Representative Hall is getting and will pass out.
Oh, yeah.
Oh, good.
Thanks, Jim.
This is a different amendment, different bill. Okay, so, yes, of course, yes. Does anyone need a copy of the amendment to HB 440? Everyone have a copy? Representative Hall? Okay. Yep. Representative Hall, could you introduce your amendment?
Yes, thank you, Mr. Chair. I'd like to introduce Amendment 0188H to 440, and the only change on this is adding the word initial on line 6, so that it's clear that it's just the initial license thing that we're talking about and not all of them. And I think we spoke about this during the hearing. So it's just adding the word initial on line 6.
Okay. Since we have an ought to pass motion on the floor, would you like to make a motion in relation to your amendment?
Yes, I would. Thank you. If we could do ought to pass as amended for 440, 0188H.
Okay. Yeah, we'll hold off. before we do that.
Vote on the amendment.
Amendment.
So
Ought to pass on the amendment. Right.
We just have to have the motion and the amendment. Then we do ought to pass as amended.
we don't vote on the amendment.
Right. Yeah, we vote on the amendment. Yes. Yeah, right. Yeah, I'm sorry. Yeah, misunderstood.
Sorry about the
Um,
confusion. Please.
Is there anyone else who would like to comment? Representative Hall, you moved ought to
Ought to
pass
pass
on the
as a-
amendment.
yes.
Was there a second?
Second.
Okay, we have second, third, and fourths on that. Cornell.
Oh, gosh.
Hall is the first.
Oh, gosh, I'd forgotten about it.
Yeah, we'll make it an, yeah, you can hold that, but then we'll, okay. Is there anyone else who would like to comment on Amendment 0188H?
Just,
Representative Terry.
just a question. When otherwise, other than an initial application, would somebody be, would somebody be doing this? I'm trying to understand why, and I can understand initial, but I'm trying to understand why initial, how does that limit those that would have to do this? I guess I'm asking the question through the chair to the maker of the amendment,
Representative Hall?
just to make it
Thank you,
clear.
Mr. Chair. I believe the renewal process.
Renewal, thank you.
Yes. Thank you.
Any further discussion? Representative McDonald?
I have another question for the offer of the amendment. Along the same lines, if it says as determined by the State Board of Education, when it's up for renewal, couldn't the State Board of Education determine that an assessment's not necessary then? And if they do determine an assessment's necessary, maybe they have a reason for doing so? Am I reading that correctly? Oh, sorry, I'll say that again. You said that other than the initial time, it may be when the license is up for renewal. and it says the assessment's determined by the State Board of Education. So couldn't the State Board of Education decide for whatever reason they don't need to take the test again for renewal, and that would be something determined by them? Is the statute allowing for that?
Thank you. Well, I don't think they have to take an assessment every time. Is that what you think? They only take the assessment to get the initial certification.
Okay. And then my question is, without this amendment, without the word initial, couldn't that still be the case?
Now, go ahead. It could be the case, but this clarifies it so that if I'm renewing, that I don't have to worry about it. It was basically a clarification with, was it Mr. Appleby was here? But it was
All
just,
right.
it was just to make sure they knew that it was just the first time. You don't have to deal with this at all if it's a renewal.
Got it. Thank you.
Anyone else? Oh, Representative Litchfield?
Thank you. I'm trying to pull up the bill right now, but this amendment was actually suggested to us through professional testimony. Yeah.
Seeing no further discussion. Madam Clerk, when you're ready, we'll take a vote on Amendment 0188H.
Okay. Vice Chairman Noble,
Yes.
Representative Terry,
Yes.
Representative Sheehan,
Yes.
Representative Freeman,
Yes.
Representative Litchfield is yes. Representative McDonald,
Yes.
Representative Tenzar,
Yes.
Representative Mazer,
Yes.
Representative Nato,
Yes.
Representative Cornell,
Yes.
Representative Murray,
Yes.
Representative Woodcock,
Yes.
Representative Hall,
Yes.
Representative Balboni,
Yes.
Representative Edgar,
Aye.
Representative Kluger,
Yes.
Representative Snodgrass,
Yes.
and Chairman Cordelli.
Yes.
Okay, so the amendment carries 18-0.
Representative Freeman, would you like to put forward another motion with the passage of the amendment?
Oh, I thank you, Mr. Chair. I think I would. I would move to ought to pass with amendment.
Thank you. Is there a second? Representative Hall?
Do it again. Yeah, because she's got the amendment.
Did you, Representative Freeman, did you want to comment while the clerk is getting the paperwork ready?
No, thank you, Mr. Chair. Well, my comment previously still
Okay.
stands. Thank you.
Any further comment on OTPA? Seeing none. Madam Clerk, when you're ready.
Okay, so this is OTPA on Bill number 440 with Amendment 0188H. Vice Chairman Noble,
Yes.
Representative Terry,
Yes.
Representative Sheehan,
Yes.
Representative Freeman,
Yes.
Representative Litchfield is yes. Representative McDonald,
Yes.
Representative Tenzar,
Yes.
Representative Mazer,
Yes.
Representative Nader,
Yes.
Representative Cornell,
Yes.
Representative Murray, Representative Woodcock,
Yes.
Representative Hall,
Yes.
Representative Balboni,
Yes.
Representative Edgar,
Aye.
Representative Kluger,
Yes.
Representative Snodgrass,
Yes.
and Chairman Cordelli.
Yes.
Okay, so that carries, to pass is amended 18-0.
Consent okay? Great. Let's move on to House Bill 222, which is repealing the requirement for an MOU, Memo of Understanding, between a chartered public school and school district regarding how students with disabilities are serviced. Before we have a motion, we did have a correspondence last night from, I think, the representative from the Charter School Alliance, Ms. Adams. I did not have a chance to pass that out to the entire committee. Could you explain? No. Or is there someone from the Charter School Alliance? Yes. explain the clarification that you wanted to make to the committee.
Can you put on the microphone? Thank you.
Yeah, and yeah, I'm sorry.
Yes.
Yeah,
Which point
some of
particularly
some
are
of
you
these
referring
emails
to?
run together in my memory.
Yes. Which point particularly are you referring to?
Um, was there an email clarifying one point that came up during the discussion about the MOUs and right? Was it someone else? Okay, I'm
I
sorry.
think it might have came from you. That's why
Okay.
I'm asking. I was like,
I'm sorry.
Um, my name is Beth McClure, and I'm the chair of the Alliance for Public Charter Schools. The point I wanted to clarify is that the oversight, there's quite a bit of oversight from the school districts for charter schools with students with IEPs. They attend, the district representative has to attend IEP meetings, progress meetings, participate. They lead the process in the IEP development and the approval. The charter school has no vote in that process. They're at the table, but the school district makes the final decision. The charter school also provides service logs for services that are contracted with the district and attendance logs. So there's a lot of oversight, much more than could be accomplished with an MOU. The original intent that I was told for the MOUs was to ensure that there were services delivered. And I had never heard anything about oversight. So if that actually was the original intent, there is a lot of oversight.
Any questions from the committee? Great. Thank you very much. And I apologize to the committee for not sending that around to everybody. So with that, Representative McDonald, did you have a motion?
Yes, I move ought to pass on House Bill 222.
Okay. Is there a second?
Yeah.
Representative
second.
Balboni? Thank you. Representative McDonald, would you like to comment?
Yes, thank you for the clarification. That's much appreciated. And along the same lines of what was just mentioned, there is already oversight regardless of the MOUs. And the current statute and law that this bill seeks to repeal has no way to be enforced, and there's not a penalty for lack of compliance. We heard during testimony that right now 94 of these MOUs are not signed, and 16 of them 2 years in a row have not been signed. So this law has not really been being followed, but it is also a lot of time and effort and legal fees that go into it. And drafting multiple MOUs, a charter school with multiple districts that they contract with, it's become needlessly burdensome. And for that reason, I would hope that we could pass this bill. Thank you again.
Representative Balboni?
Yes, thank you. I think that Representative McDonald carried most of the points that I had brought forward in my testimony, but I would just say that, the two groups are working together quite well in trying to, prevent and to solve any issues that arise. And any legislation that comes forward, if there needs to be further oversight, this isn't the way to do it. So that's it. Thank you.
Thank you. Any further discussion from committee members? Seeing none. Madam Clerk, to you.
Thank you. This is House Bill 222. The motion is ought to pass. Vice Chairman Noble,
Yes.
Representative Terry,
Yes.
Representative Sheehan,
Yes.
Representative Freeman,
Yes.
Representative Litchfield is yes. Representative McDonald,
Yes.
Representative Tenzar,
Yes.
Representative Mazer,
Yes.
Representative Nato,
Yes.
Representative Cornell,
yes.
Representative Murray,
Yes.
Representative Woodcock,
Yes.
Representative Hall,
Yes.
Representative Balboni,
Yes.
Representative Edgar,
Aye.
Representative Kluger,
Yes.
Representative Snodgrass,
Yes.
and Chairman Cordelli.
Yes.
So that motion carries 18-0.
Consent okay? Great. There is an amendment to House Bill 699 that I just passed out. Representative Cornell, would you like to take a brief recess to discuss the amendment with your team?
Yes, please.
Great. So we'll take a brief recess. Excuse me. Yes, a brief caucus. Right. Thank you. And so as soon as I get confirmation of that, we'll take up a couple of more bills. And just for anyone who's here who might be interested, at 1 o'clock, we're going to have a work session on 3 bills related to bullying. And it's not mandatory attendance for substitutes. It looks like we're live in living color on the internet. So we'll move on to a couple of more bills this morning. The first will be House Bill 719, repealing the use of unused. Looks like we're live.
So if, if it does it, my first question would be, are you,
So a few committees are live, evidently. So this is unused district facilities by charter schools. And I call on Representative McDonald for a motion.
Thank you, Mr. Chair. On House Bill 719 FN, I move ITL.
Do I have a second?
I'll second that.
Representative Freeman. Representative McDonald, would you like to discuss your motion?
Yes, I would. Thank you. 719, it repeals the right of first refusal to chartered public schools when purchasing or leasing unused school district buildings. Since enacted in 2022, the Department of Education, to the best of our knowledge, has not received any complaints from school districts regarding the right of first refusal, and only one chartered public school has leased a building from a school district since the law was enacted. That's what was said at testimony. So I think that this really is addressing a non-existent problem, but also has the potential to impede charter schools and their expansion, chartered public schools, I should say, such as the reporting requirements that would also be repealed, and it would make charter schools less likely to know of available buildings. And if they don't know of an available building, then how can they bid or make an offer? So I think at this time, this bill is expedient to legislate. So thank you.
Thank you. Representative Freeman, further discussion?
No, but thank you, Mr. Chair. I echo the sentiments of Representative McDonald.
Thank you. Any other committee discussion on this bill, 719? Representative Balboni.
Thank you. I just want to say that I think there was some interesting testimony brought forward, and certainly I read through a lot of the online support for the bill, emphasizing local controls for school districts to be able to handle their own real estate in a way that best suits the community. However, I would agree with Representative McDonald because we really don't know. We really haven't seen how it affects. So let's wait and see if it does become an issue. I think that some of the original language in the bill that passed could be problematic, but until we see what happens, I don't think it makes any sense to do anything with it this time. Thank you.
Thank you. Anything further? If not, Madam Clerk.
Thank you. The motion is ITL on House Bill number 719. Vice Chairman Noble,
Yes.
Representative Terry,
Yes.
Representative Sheehan,
Yes.
Representative Freeman,
Yes.
Representative Litchfield, yes. Representative McDonald,
Yes.
Representative Tenzar,
Yes.
Representative Mazer,
Yes.
Representative Nato,
Yes.
Representative Cornell,
Yes.
Representative Murray,
Yes.
Representative Woodcock,
No.
Representative Hall,
Yes.
Representative Balboni,
Yes.
Representative Edgar,
Aye.
Representative Kluger,
Yes.
Representative Snodgrass,
Yes.
and Chairman Cordelli.
Yes.
Okay, so this is 17-1.
Is consent still okay, or would there be a minority report?
There will not be a minority report from this minority.
Okay, so consent is all right? Thank you.
Thank you.
And we'll give the clerk a moment, but there's going to be one more bill we're going to take up, which is on the list for tomorrow, but we'll take it up now. And that is House Bill 184, related to study committee looking into changing the school start times. No, we're not gonna. Yeah. Yeah, 'cause I think the calendar says. 184? Before we take up 184, let me check on one thing, if I might. So since House Bill 184 is in the calendar for tomorrow, we will not take it up today. We can, Representative Terry does have an amendment to that that we can pass out now so everyone has a chance to look at it in advance of tomorrow morning.
Is it appropriate to say anything at all or just distribute it?
Just distribute it.
All right.
We'll take that up tomorrow along with the other bills that are on the calendar tomorrow morning. And so with that, I think that we are done for the morning, and we are back at 1 for our work session. No. Thank you very much.
Yeah, I figured we couldn't do this today because it's on the calendar for tomorrow. Yeah. However, let me not say anything that I should not say. Yeah, thank you. Okay.
Yeah, it's just a work session, so.
All right, yeah, whatever you need.
Let me ask,
You do understand that guilty that made a motion, not one that God gave. All right, if you feel guilty, that's on you. God did not give us the emotion. There only goes to the time. Oh, I don't know who. Yeah.
This must have been heard while I was.
I'll make it work.
Because I just looked at it and I was like, wait a minute, we didn't hear this one.
Okay, we are back in session, and we have a work session actually scheduled for the next period of time, dealing with 3 bullying bills. HB 108 is relative to bullying and cyberbullying across multiple school districts. HB 384 is prohibiting bullying in schools. And 673 is relative to bullying and discrimination plans. I'll just note for everyone's benefit, HB 384 is an early bill. So we have to vote it out by March 6th. But we can continue working on the other 2 bills and use one of them as a vehicle to try and accomplish something on the topic. If you want to, and I'll also mention, if you have your books out, this topic really begins on page 601, RSA 193F. Oh, was it something I said? Yeah, I think it might be helpful to reference at some point the current statute because it does go into everything from bullying and cyberbullying to retaliation and training, reporting, and the process of investigating bullying incidents. So just as a refresher, we'll take a look at 384 first. And the topic starts on page 603. 384 first was, I think, the first bill we heard on the topic. And it is quite prescriptive in terms of what it requires, including conflict resolution as part of it. And one thing that drew quite a bit of attention during the hearing, I believe, was the requirement for appointment of a bullying officer. We had quite a few people testifying, and I'm not sure how anyone feels about, let's talk about the bullying officer first, because that had quite a bit of attention in the hearing. Does anyone have any thoughts on appointment of a bullying officer?
If I may, Mr. Chair,
Yes.
seeing as most middle schools and all high schools at this point have an RSO, resource school officer. And I'm not 100% sure what their responsibilities are, but why would we add another officer if we have an officer in the schools who may have some insight, or this is already part of his responsibilities? It just seems duplicative.
Representative Murray.
Thank you, Mr. Chair. I think to that end also there was some conversation about whether or not this would add an additional layer to the juvenile justice system. So I hear Representative Freeman's point as well. I am curious as to whether or not SROs have the ability to have that role or potentially play that role in addition to their already tasked responsibilities. And I think there was some discussion, if I remember, about whether or not that would be in their purview.
Mm-hmm.
So I don't know if there was anyone able to speak
Right.
to that or answer that question for you.
Just following up, when you talked about children's services, I think maybe you were referring to that the last paragraph in Chin's. Right. Yeah. Yeah. Further. Yes, Representative Hall.
Thank you, Mr. Chair. Did we talk about the resource officer kind of like being the good guy in the school and making that person the bullying officer? Maybe I'm making this up. The bullying officer giving a role that's more punitive, so to speak, rather than this positive relationship. I don't know if we talked about that or not, but in my mind, I think of that resource officer was supposed to be this liaison between the kids and law enforcement and whatnot. So I
Right.
don't know. Just a thought.
Right. Yes, go ahead.
If I may, Mr. Chair, also, I think that we had also heard from the disability rights advocacy groups about whether or not there was adequate sort of resources or representation for individuals with disabilities if they were in this space. If I remember correctly, there was some concern about whether or not that could be construed as bullying when in fact it was just a part of their disability.
Yeah, there is a definition on page 601, bullying and cyberbullying definitions. I believe we had looked at that. I'm not sure if it was last term or the term before, and did not change. It might have been last term. Did not change any of the definitions. But yeah, I think the current definitions are adequate in my opinion. Representative Cornell.
I think the definition of the bullying officer was somewhat vague also. It could be the resource officer, but it also says school boards and boards of trustees of chartered public schools, which I don't know if they have resource officers in chartered public schools, shall appoint bullying officers for their districts or So is this saying that they can appoint the phys ed teacher to be the bullying officer to do these list of duties? It doesn't really say who the bullying officer is, I don't think.
No, right. Leaves that open. Yes, Representative Hall.
And I know when Ms. Rosenberg spoke from the Disability Center, she also was concerned, I think, according to my notes here, of having people that aren't trained in evidence-based behavior. That was a concern of hers. So it should fall to your point.
If I may ask a question of the representative who made that comment, do you know of any evidence-based techniques? Because I went looking for evidence-based techniques on bullying and I wasn't able to come up with anything.
Yes, you mean? Oh, if it's for me, I don't know. I'm just looking at my notes.
Right. Does anyone have any opinion on the children's services and investigation? That's in new subparagraph 3 on page 2.
Thank you, Mr. Chair. One of the things I think we had referenced 169D as the area that spoke about chins, and I think we heard conversation around it normally being around truancy, runaway students, criminal code violations, severe cognitive fire setting, that kind of harm.
Right.
And there was, I think, some concern about whether or not this would open the door wider for additional chins petitions, and to that end, what would the cost then be
Right.
to DCYF if chins is under DCYF, I think, and they're already understaffed to a degree.
Right. Yeah, and I think that's referenced in the fiscal note as well. Yes. Sure, is okay.
One additional conversation and question that I had actually personally had about whether like student protection or student rights and whether or not a chins petition would open up a situation where a student would need a guardian ad litem potentially. And I think that, you know, when we talk about guardian ad litems, they're there on the child's best interest. So I do have a lot of questions about how that process would work to ensure that if they were going through a chins petition that a student and or parent, you know, parents can be a part of that process, but oftentimes there are guardian ad litems awarded by a court to help
Right.
a child move through a system.
Right. Yeah, I don't think we need to get that involved with our bullying statutes at this point. Representative Balboni?
Thank you. I'm just referencing some of the policies that districts already have in place, and the one in particular I'm looking at is the JICK policy.
Yep.
It has actually a lot of what is in this bill. When you talk about a bullying officer, it appears that like in the JIC policy, they talk about the building administrator being in charge of tracking those complaints and making sure that they're followed through. So I think that is already covered in the policies that the school districts have. So what I don't know is, I think all the school districts are required to have this policy. And my question would be, is this all this necessary for what it's trying to accomplish? I think that there are procedures already in place.
All this, do you mean
It's specifically the referencing to the CHINS program
Okay,
and all
right,
of that. Yeah,
yes.
sorry.
right? Yep. Is there anything in statute currently that requires naming of someone to track bullying cases? It does have some language about principal or designee being involved, which I guess would be similar to this school administrator. How about the requirement in this for the conflict resolution aspects, which are on the first page? I think some discussion of that has come up with previous legislation, and there was concern about, in some cases, getting the perpetrator and alleged victim involved together, whether that's always a good policy or not. And that's also where Representative Freeman it talks about on line 20 evidence-based methods. I don't think there is anything in current statute requiring conflict resolution that I recall. So from what I'm hearing, yes.
I don't know about putting it into law because I think each situation is sometimes different, you know, and where sometimes it might be a good idea to do conflict resolution and have the students sit down and discuss it and work it out. And other times that wouldn't be the best
Right.
solution. So, you know, and this also, I think the intent of this was to get parents more involved in trying to solve it. And again, I think that's something that can be situational too, to try and get the parents to,
Right.
to come in and talk about it or to work
Right.
with their child about doing something. So
Yeah. And there are requirements in statute now about notification of
Yep.
parents and timeframes for doing so. Anyone else have any feelings about conflict resolution being required? Right. Okay.
Do the students, like maybe at the beginning of the year, do they go through anything about like not bullying? Like, are they informed about that at all? And go ahead. I'll recognize you.
Interesting you just asked that because I was just reading on page 603, 193-F:5. Yes, if you read that, it talks about the training and actually evidence-based educational programs which are supposed to support that training for anyone working with the students, including volunteers, employees, etc.
And pupils and parents as well. Yeah. Representative Marie?
Thank you, Mr. Chair. I think also most districts at the beginning of the year provide a school code of conduct, and those are available generally online or in person in hard copy, that the students do receive those at the beginning of the year. They're asked to review them. Parents are well aware of what those code of conducts are as well. So I think there are some procedures in place around that, if that's what you were asking, Vice Chair Noble.
Yeah.
I think so. The other thing I did want to mention with regard to this and maybe others is that I just want to make sure that we're being very careful that we're talking about things as like an alleged perpetrator until the investigation had gone through. I know that this bill specifically says the word perpetrator first, assigning that maybe they have already committed the act before the actual investigation or whatever is complete. So they're allegations until the findings are done.
Right. Okay, so
Just one other thing, just came to mind as I was reading through it. Children of different ages would require much different interventions dependent upon it. And this bill really doesn't make that differentiation with what you would do in a case of an elementary school student versus a high school student. So I think that's important to note that school districts should have the the option of choosing the Beth intervention method that fits the family, the student, and the school and the building culture itself.
Thank you. So what I'm hearing is that the committee doesn't have any interest in moving anything forward to involve getting involved with CHINS or DCYF or anything like that at this point. And that there is a concern about mandating conflict resolution in all cases. If I'm summing things up correctly. Representative Noble.
There is one piece that I do kind of like about this. And it's on line 21, participation of the perpetrator in age-appropriate anti-bullying class or workshop. Not that I'm saying that they need a full class or workshop, but if they had to watch a video, like, so that they understand that impact, it might be easier for them to understand the impact when it's not somebody that's like talking at them, like when they're in trouble, you know what I mean? So I think that this is the only piece that I think might be helpful.
I agree actually with Representative Noble in terms of, but I think that is included in the training component that is referenced in the law.
Okay.
That would be what I would say. Like if you're having workshops, or I know like in like in middle school in my town, when there were instances of bullying taking place, groups were put together and kind of taken through steps and given like, how would you feel? So I do know that the social workers at the individual schools treat each instance very seriously and work through the student population. So I would say that it's probably already included in the law.
Okay.
I am also aware of cases, however, where the school has not been maybe as diligent in addressing a bullying case as we think they should be. And there is no real teeth in this in terms of the reporting or parental involvement or anything other than F9, which is a private right of action. So that, could be something else that's, required via policy or something else. Just to consider. Do you want? Yep.
Question about
Sure.
the section that you just brought up. Has this ever been used? Do you know?
F9?
Yeah.
No. Let's take a look at 108, which I think is Representative McDonald's bill. And I believe, Representative, you also had an amendment that I think was passed out.
Yes, during the lunch break, I passed out Amendment 0446H to House Bill 108.
And since this is just a work session, we're just working off the proposed amendment. Is that what we're not obviously?
No, right, we're not.
Okay.
Yeah. Just for
Yes.
discussion.
Okay.
Thank you.
Do you want to talk about the bill and the amendment?
Yes. During the hearing for House Bill 108, which I believe was about a week ago or so, there were some concerns raised regarding the bill as presented. So the amendment aims to address those concerns. And it also takes into consideration some points that were raised by the New Hampshire School Boards Association. And so it's very minor changes. And the amendment replaces the bill as well.
Yes, Representative Hall.
Yes, Representative McDonald, can I call him Representative McDonald? Could you just explain like what actually changed? If I had to do the side by side?
Sure. On the amendment, if you look at line 11 and onward, that's the part that's changed, and I'll just read it to you. In cases of bullying and or cyberbullying across multiple school districts, the principals or designees of all districts involved shall be responsible for conducting an investigation and are encouraged to collaborate. In such cases, the investigation shall be initiated by the principal or designee of the first district to learn of the incident. My intention with this is because within the original bill, I said where the action originated. But if we haven't had the investigation yet, we often don't know where the action originated. So the point of this is to say all districts that we believe to be involved should participate. And then the district that's the first to hear about the incident is the one to initiate that investigation. So this encourages more collaboration among the districts. And then I'll point out that it says principal or designee. So if someone in that district is more fit, it really allows for the local control to determine who is the person in each district responsible for these type of things.
Just Representative Murray.
Thank you, Mr. Chair. Did we get any clarity on the circumstance in which, like, potentially it could be an out-of-state party that would participate in a circumstance, like in the event of like potentially cyberbullying or something like that, where it was out of state? Did we have guidance of like how that initiation across state lines would occur, or does that have to, can that simply be done by a district on their own, or does that have to involve another entity to communicate across state lines to ask for that collaboration?
Yeah, that was a question that came up in a prior bill also related to cyberbullying. You know, it could be someone in California.
Right. Right.
I'm not sure if that would be defined as cyberbullying or some other offense. Could we have a lawyer join us at the table maybe for her opinion?
Sure.
I
I mean, I don't.
I think there was one sitting in the back who works for the department. Yeah, right. Yeah. Well, yes, we do have another lawyer in the room also. Right. Yes. And they will always agree.
It's true. I know, I'm married to one, so
Yes.
it's a great time in my house. Well, good afternoon.
Could just look closer to you. Yeah.
Oh, that's right. You want me to be louder. No one's ever asked me to do that before. So Diana Fenton, an attorney with the Department of Education. So I'm really appreciative that this committee is taking up this issue of bullying across districts. We have had this case occur. It happened in Profile up north. I don't know the short answer to your question. I think it is an excellent question, and it is just a matter of time. I wasn't really thinking California. I was thinking more along the lines of Massachusetts. But it doesn't matter, does it? Because the world is wide open. So I think in that instance, it was challenging enough when you had two districts having to work together who was responsible for taking the lead. And I think that what I liked about this language is that it specified who was responsible for the investigation, because someone has to take the lead. In terms of, across state lines, that is inherently challenging. And I would assume, without knowing the exact facts, my inclination would be that there would have to be discussions between the state agencies. That's how I would initially handle it if that fact pattern were brought to my attention, which I think, again, it's just a matter of time until that occurs. And my inclination, again, and this is all speculation, right? Before we have an exact fact pattern, we don't know how it's all going to play out. But my inclination would be that the Department of Education would work with its counterpart, the Massachusetts Department of Ed, and have the Department of Ed down there reach out to the district. That's how I would approach it initially. I think that if you had a district reach out to a Massachusetts district, it wouldn't be effective. Not because they don't want to work together, but that's not your best route of communication.
Thank you, Mr. Chair. So what I hear you saying is district to district communication would probably not be the preferred, first set of communication to open the lines between two state. If there is suspicion that there has been an offense out of state, to Representative McDonald's point, we want to get to the genesis of what happened, but there's nothing compelling that the individual district to have to communicate between one another. Is that what you're saying?
I think that's right.
Okay.
Yeah, I think what you said is exactly the issue. There's nothing to compel that cooperation. And I can only compare it, analogize it, if you will, to my prior work as a criminal prosecutor. When we had crimes or a suspect go over state lines, we wouldn't defer to a local police department to coordinate with the other local police department. That would be ineffective. It's not that they don't want to work together, but you would have to raise it to that higher level. So I think when you have two school districts within the state of New Hampshire, we always defer to local control. And this is a great idea to say, who leads this? How does this get accomplished? Because you need to have that direction. The school districts need that direction. But when you have competing interests going across state lines, that is just a completely different analysis. And I think you summarized it perfectly. There's nothing in this legislation, and as compelling as this legislation can be, it's ineffective in Massachusetts, right? It's ineffective in other states. So how does that get accomplished? Again, my go-to would be, I would refer to the state agencies.
May I have one more follow-up?
Sure.
Okay. So my additional question, is there a possibility after the initial state agencies are contacted that there would be other parties contacted between the states, potentially law enforcement, attorney generals, something like that?
Absolutely.
Okay.
And I don't think it's outside the realm of possibility to include the Attorney General's office in that discussion. It's going across state lines. That is a totally different analysis. And I would be foolish to sit here and say it is not a big deal. Case in point, when the Department of Education wanted to create an MOU, a memorandum of understanding. It's not a contract, it's a memorandum of understanding. Police departments do it all the time, with the state of Massachusetts to have the ability to check the Massachusetts Central Registry before the Department of Education license someone to teach. That is a common sense policy, if you will. To check that registry, because we have so much back and forth traffic between our two states. We all know that. We had to undertake legislation in order to enter into a memorandum of understanding. We weren't doing a contract. We weren't doing anything that was binding on either state. There was no financial responsibility from either state. And yet I had to come before this legislative body and pass a law that allowed me to then draft a memorandum of understanding. So people ask me, why did that project take you 5 years? Well, let me tell you why it took me 5 years. Because we were going out of state, and because we were going out of state, working with a fellow state agency, it had to go in front of the executive council.
I thought you were going to say it took you 5 years because you were dealing with the New Hampshire legislature.
Oh, no, I would never say that, especially since my microphone is on. But I use that to highlight the point that when you are going out of state, the analysis changes, and it changes significantly.
So looking, I'm sorry, Representative McDonald.
Thank you, Mr. Chair, and thank you, Attorney Fenting. To address out-of-state investigations, would this bill benefit from saying that the district should contact the New Hampshire DOE so that the New Hampshire DOE could contact the state agency in Massachusetts, California, or wherever? Or would another line address the issue?
I think it could be a start. You know, and again, I really do applaud this committee for thinking that globally of how do we address these issues that we know are coming. I think in my work, it's so easy that we're always kind of behind the 8 ball instead of getting out ahead of it. So I really applaud you for that. Maybe it's as simple as a line of, you know, in cases of bullying and or cyberbullying across state lines, the New Hampshire School District, and please don't start writing. I'm just spitballing here. The New Hampshire School District will contact the Attorney General's office. The Attorney General's office would then refer it to the Department of Education if it's appropriate. But recognize that these cases of bullying and cyberbullying can very quickly become criminal in some instances. Right. You just don't know what the fact pattern is going to be. So I would feel more comfortable with having the Attorney General's office looped into that, and they can certainly and would refer it to the Department of Education if they felt it was appropriate.
That's really helpful. Thank you.
You're very welcome. Thank you.
Representative Freeman.
Thank you, Mr. Chair, and thank you for coming in front of us. And correct me if I am incorrect, but isn't there a federal agency that deals specifically with cyberbullying? For some reason, in my memory bank, I do remember hearing about an agency that deals specifically on the federal level with cyberbullying because some of these cases are interstate.
Sure. There very well could be. I'm not aware of it off the top of my head. It wouldn't surprise me because you're right. The impact it has is really quite breathtaking.
Yes, Representative Litchfield.
Thank you, Mr. Chair, and thank you for taking my question. I just want to make sure that I'm understanding this correctly. So if we're putting it into law, that we're going to go to the DOE if any of the bullying happens between state lines, would that deter some people from actually going to get help? Like, it just seems to me like it's subjective. Like, wouldn't we want them to have local control to decide whether or not they actually need to get the DOE or the AG involved? Or I feel like I'm missing something here.
I think the issues that have been raised are just recognizing the complexities, the inherent complexities that arise when things go across state lines. And because of those inherent complexities, deferring to local control might be ineffective. And so when you look at the law book that I didn't bring with me to the table, we have interstate compacts with Maine and Vermont. And as a quick aside, when I started at the Department of Education, I had a wonderful colleague who was guiding me those first few months. And we don't have a similar interstate compact with Massachusetts. We don't have one. And it was fascinating to me. And she said to me jokingly, she said, well, that's because it takes an act of Congress. And she was right.
Yeah.
It does.
Yeah.
And we have a school district that is a Vermont, New Hampshire school. And they have struggled historically as to what law applies. Because the reality is, and I'm simplifying it, so please forgive me, but the reality is the minute you go into another state, right, it's just a different analysis. And it is because of that reason that it would be ineffective to just say, we'll defer to local control. Who's local control? When I worked with the New Hampshire Vermont school and they were struggling because they never decided which law would apply, they suddenly were at odds. And their whole philosophy was, well, we'll decide what law will apply when the issue comes up.
Mm-hmm.
And I remember sitting in the school board meeting going, what? They just kicked the can down the road. They needed to decide which law was going to apply and stick with it. And inevitably, deferring to local control, that's going to be the problem that inevitably you'll run into. Which law applies? And that's why in those situations, if within the state of New Hampshire you defer to local control, that's an effective solution. And that's for this policy body to make that decision. But anything over state lines just gets inherently more complicated, and local control will probably not, you will probably see immediate issues if that is how you defer.
Yes.
And thank you. So I just did a Google search, and the FBI does have a cyber division, which deals with
makes sense.
these
Sure.
these things because it's interstate and not intrastate.
Yes.
So thank you for that.
Well, I didn't have the answer, so you shouldn't thank me for it, but I appreciate the.
No, you actually put that in my head, so, you know, if you hadn't sat there, then I wouldn't have thought of it, and the process wouldn't have gone aside.
But it, I think you're being a little too gracious, but I appreciate it. But I think your point is well taken, right? It's not a local state agency that's in charge of that. It is the FBI, and it is a division of the FBI, and there's a reason for that, because you have to have that federal power in order to have that oversight of the states.
So I'm thinking generally is what we need, a few sentences, maybe a paragraph on the topic of cyberbullying across state lines, and a procedure that, you know, just looking at things, could be an added subsection under 193F4. And possibly also something in F6 in terms of reporting. Representative Murray?
Thank you, Mr. Chair. Do any of these proposed language options regarding either FBI or Attorney General's office, should we get input from those agencies?
I don't think it would be a, well, if someone's going to contact it, I'll do the local AG and you can do the FBI. How about that?
I'm just asking the question.
I
because
know,
wanted
I
to
know.
make sure that
Right.
we're not getting
Yes,
ourselves
I
into
don't
a
think it
place
would.
where
I don't think it would be a bad idea to contact both and indicate what we are considering in terms of legislation on the subject.
I would agree 100% that the Attorney General's office should be looped into that language that you're contemplating inserting. In terms of the FBI, the Department of Safety, they
Okay.
have worked
They
with
would have contacts.
the FBI. There should
Okay.
be some contacts there.
Okay.
They have to clear any law that is written about dissemination of criminal records with the FBI, so that might be an avenue that
so
could
New
be
Hampshire
pursued.
Department of Safety instead.
Yes, the New Hampshire Department of Safety.
Okay.
So, any further comments on cyberbullying across state lines? So, Representative Murray, did you want to contact Department of Safety, and would someone contact the AG's office? Representative McDonald, would you
Yes,
do
I
that?
can do that.
Great.
And Representative Murray, I have a contact at the Department of Safety. I can send you her information to assist you. Sure. And Representative
There's so many of them.
McDonald, if you need assistance with the AG's office, I can.
Yeah, right.
I used to work there, so sometimes they still talk to me, but
I appreciate it. Thank you.
of course. Anything further?
No, thank you very much.
I will be in the cheap seats in the back.
Great.
If you need me. Thank you so much.
So I think if, we can accomplish something on this topic, I think that would be a good accomplishment for the committee on this legislation. Does anyone have any questions, Representative McDonald, on her amended language to 108? Representative Hall.
Question, actually. So at the end, it shall be initiated by the principal or designee of the first district to learn of the incident. I'm just wondering if they might, they might not be sure who's the first district. Are they going to talk to each other and say, I got it first, I heard it at 2:00, you heard it at 3? I mean, do you envision that happening or not really?
I can't imagine that happening, but I definitely understand the concern. It's not so much the first district, just that somebody is doing this, which is my goal all along. But it definitely looks like there will be an amendment to the amendment, so I will take that under advisement.
It's just a thought. I don't know if it would happen or not. Thank you.
Becky, since I think School Boards Association's name was mentioned in connection with this amendment, would you like to step up to the plate?
Good afternoon, members of the committee and Chairman Cordelli. For the record, Becky Wilson from the New Hampshire School Boards Association. Thank you. I do know that Mr. Christina and I have worked a little bit on this after the original hearing to try to help clear up some of this confusion, I think, and to make sure that Representative McDonald's concerns were addressed, and that you can try to make it as clear as possible in these situations. I think that was the intent of offering this language, so that somebody would take the initiative to start the investigation. If there's other things that I can help with, I'm happy to try to address those. I think Attorney Fenton probably answered most of those questions in terms of the legality of who can do things across state lines. I think it's just in terms of, the day-to-day processing of bullying reports and bullying investigations, and trying to determine when kids are being mean to each other versus whether or not it is a bullying situation based on the definition that is in the law of bullying, whether or not you complete the bullying investigation and determine it is actually bullying. There's a lot of pieces to this process that are very prescriptive, and I think that just trying to make sure somebody starts that process is the intention of this amended language.
Representative Murray.
Thank you. I know that we did talk about an amendment to an amendment, and I was curious to know whether or not what a general time frame for these investigations are. I know there's conversation about granting an additional 7 school days, but I can imagine if these are across state lines, this may take quite some time after the initial investigation if it were determined that there were other agencies that needed to be reached. I'm just curious if anyone knows what a general time frame for this type of inquiry is.
Thank you for the question. There are timelines specified in the current bullying law in terms of how long you have for certain parts of the investigation and how long you have to complete those. I was just trying to pull it up off the top of my head, but I have about 800 windows open. I apologize. So there are very formal timeframes for a bullying investigation in terms of when you have to start the bullying investigation once you've been alerted that there is potentially a situation that is bullying, who has to be notified, when you have to notify them, how long you have to make a determination, etc. That's all right within the law.
Part of that is in the amendment, the 5 days and the 7 days.
Right.
Right.
And I do, I do see something in subparagraph J of
Yep.
193F4. Is that maybe where that came from?
It is, yeah. Yeah, I don't know if we want to attach any number of days to when we get state agencies involved. Yeah.
Yeah, I would also just speak to, for the administrators that are completing the bullying investigations or their designee, whoever those people are that are doing those, most often it is the principal or an assistant principal or some other school administrator. That is by design to ensure that you have a person with that level of influence at the school level that is making those determinations, and not, I think somebody had made a comment earlier, designating the PE teacher as the bullying investigator. There's some reasons why you would typically have an administrator doing those investigations, because there are so many timeframes and legal aspects of making sure that you're completing that investigation with fidelity. It's very difficult sometimes when you get a report of what is considered bullying from a student. Not that it's unfounded. Oftentimes they are founded. Investigations of bullying are founded that way, but I don't know if any of you have ever worked with 7th graders, but you can get reports of somebody being bullied by a 7th grade student, and by the time you get the students together to try to interview them and figure out what is happening, I think somebody mentioned this earlier, you find out they're just being mean to each other. It doesn't necessarily meet the level of qualifications of bullying, but that's why that investigation process exists, to make sure that people are going through the process with fidelity and ensuring that you are making determinations about whether or not there's actually bullying as it's defined in the law versus students are being mean to each other, which happens for sure and needs to be addressed regardless. But in a very different way. Would you address a student who has been founded as a bully or bullying versus a students that are being mean to each other?
Representative Freeman, did you?
Thank you, Mr. Chair, and I think I found what Representative Murray was looking for under 193F4 Section I, which says a provision that the superintendent or designee may within the 48-hour period grant the school principal or designee a waiver from the notification requirement if the superintendent or designee deems such waiver to be in the best interest of the victim or perpetrator. So you're concerned with if they're working with other agencies or other states, would it be enough time? I think this provision right there would allow that time that's necessary to complete the investigation to occur.
And K does talk about requirement for the principal or designee to develop a response to remediate the bullying or cyberbullying. There could be a line added in a number of different locations, including the reporting in relation to cyberbullying, especially across state lines. There, in reporting, there is a requirement for bullying and cyberbullying to be reported to the department, which makes that available as part of a safety report annually. We might expand cyberbullying on there, just to indicate something. If it's cyberbullying within state or across state lines, because it'll probably will happen and come to our attention while some of you are still in the legislature.
Yeah, I would just ask the committee to be mindful of the fact that there are differences between disciplinary consequences for bullying versus interventions for a student who has been found as bullying somebody versus the victim's interventions, what they may need if it's founded. And certainly, I think I heard something earlier about, feeling as though perhaps the language didn't spell out as strongly sort of what is the consequence for the person that has been bullied, or making sure that people are aware that there is some sort of disciplinary consequence. But the people that are completing these investigations, even with founded investigations of bullying, the part of the reason people in the district are responsible for doing those investigations is because they will have access to individual student information about a student's potential needs, whether or not they are potentially covered by special education, whether or not there are some other, situations or extenuating circumstances that could be addressed in a different way other than just a disciplinary consequence. So being cautious about spelling out specifically that you want certain consequences for certain things. There's a lot of reasons why people may or may not know what the consequence was for a bully or a founded bullying situation. There's lots of reasons where that's probably being addressed, but perhaps not in the way people would expect if they're not involved sort of in the inner workings of that.
Right. And just for everybody's timelines on this, as I mentioned, 384 is an early bill. I have that tentatively scheduled for an exec session on March 3rd. And the other two bills, 673 and 108, for March 10th. So as we're trying to make contact with various agencies and come up with some language, we'll need to slot in some time, maybe during that week of March 5th. And everybody has all sorts of time next week to work on these things.
I would just also mention quickly, I don't know, and Attorney Fenton could probably answer this better than I could, but what the intersection would be for situations which would also cross the line into a safe schools violation. That would involve typically the school district working alongside or at least providing information to their local police department, and they would be involved, and there are some incidences of bullying that I think could on occasion rise to the level of also falling under the safe schools violation. So that would also involve other agencies or MOUs or school resource officers, et cetera. So.
Right. Great. Thank you very much. Anything else with 108? Okay. Take a look at 673, I think, was the third bill. This is Representative Selig's bill. That was, I think, trying to go down the road of bullying or cyberbullying against a quote-unquote protected class. Representative Marie?
Thank you, Mr. Chair. I happen to agree that there is probably a circumstance in which we would include some sort of component, potentially a referral to the Human Rights Commission or some sort of other circumstance with regard to protected classes and violations targeted against them on that nature. And I don't know if that, I guess, to our conversation about combining different components of different pieces of legislation, if that's something that we were interested in bringing bills together, potentially, but I do think that that is an important part of our conversation, or should be.
Would be human rights violations?
Correct. I mean, I when there are acts against a protected class, is that, I guess my question is that where that would go, to the Office of Human Rights, or is that where maybe Attorney Fenton again could be helpful in that way? Like, I'm not entirely sure.
There's nothing in statute now that I know of in the bullying or safety statutes in that regard. Representative McDonald?
Along the same lines, thank you, Mr. Chair. I have a question about the protected classes too. It seems to me that on line 11 and subsequent mentions of protected class, there should be some sort of statutory reference or maybe a list of what the classes defined under this chapter of law are. And the reference just appears to be absent. I don't know if anyone knows off what reference we would include.
Yes.
Is that something maybe the department knows anything about? Could they speak to that?
I saw some hand signals from the back, so I think
okay.
that they might have an answer in a few moments.
Okay.
Smoke signals from there.
Yeah. Yeah, because how far do you go with a bullying case before you go into other acts such as hate crime legislation?
I don't know the answer to that question, Mr. Chair, but
Right.
in the event of a circumstance that would warrant that, I think we need to be prepared to be able to make sure that that is something that is enumerated, whether it is to the Office of Human Rights or some other entity. I don't know, but that would be dictated by the findings, I believe, in the investigation. I don't know.
Yeah, I think with a complaint to the Human Rights Commission, there is an issue whether that complaint has to come from an individual, or we had legislation in the past, and I cannot remember the outcome. I'm sure someone might remember the outcome about the ability of the Department of Education to file a complaint with the Human Rights Commission because of situation with the victim who was involved in the complaint, or multiple victims. Would each parent file a separate complaint, or would it have, so there was legislation about that. I just can't remember what happened with it, but I'm sure someone can. And perhaps that someone would be Attorney Fenton.
So good afternoon again, just for the record, Diana Fenton with the Department of Education. So in reviewing, and I just want to make sure I understand your question. Reviewing House Bill 673 relative to school bullying and discrimination plans. I'm looking at line 10 and 11, the targeted acts against a protected class. So your question in essence is it appropriate to report it to the Department of Ed or the Human Rights Commission? I think it would be to the Human Rights Commission. I think that makes the logical sense on that piece of it, yes.
Right. Yes.
I guess to that end, I guess I am advocating for some sort of caveat or facet of that language from 673 and potentially Representative McDonald or another like version to be that portion to be enumerated somewhere in a new version of something we have.
Do you know what happened with, do we now have in statute the ability for the Department of Education to file a complaint with the Human Rights Commission?
So my understanding on that law that was passed previously The Department of Education was not successful in
Oh,
requesting on
Right.
behalf of an
Yes.
individual or school district.
Right.
Requesting an investigation. And to be clear, the way the law was written and the way it was interpreted by the Attorney General's office, and they put out a memo on this, was that the Department of Education was not to do the investigation of those claims of discrimination. Those were to be investigated by the Attorney General's office or the
Right.
Human Rights Commission. And that if there was a finding, then the department could impose discipline on an educator's license if that was appropriate. But the investigation itself was not done, nor was it intended to be done by the Department of Education.
vote.
In this circumstance, we're not necessarily talking about educator licenses here. We're talking about an investigation
Right.
of bullying incidents between pupils. Is that my understanding? So it's a different set of circumstances.
That is correct. Yes, so I was answering your question as it related to the language in House Bill 673, namely lines 10 and 11, and then Representative Cordelli had asked a question about the department's ability on a prior bill. So my answer was to that. But you're right, this has nothing to do, to the best of my knowledge, with educator license. It's student bullying.
Right. So, on lines 10 and 11, if there were substantiated incidents, the investigation conducted locally was found to be valid complaint. And the victim was a member of a protected class, yet to be defined. Such incident would be reported by the, or may be reported by the local district to the Attorney General's office.
Yes?
Is that, I don't know, yeah, I'm not sure. Would that be a correct summation of what I'm hearing, Representative Fenton, do you think?
I think that's accurate based on this committee's discussion. I know there is a bureau or division, I'm not sure which, at the Attorney General's office that would handle these types of cases. And so it might be worth a question to them to find out if they're comfortable with the referral to their agency or the Human Rights Commission, or both. I will defer to them on that. And also defer on the language if it is a shall.
Right. Right.
I can definitely include that in my questions to them.
Great. Okay. So does that take care of what we want to look at as possible amendments to a bill or bills? And we could save discussion until we hear back from Representative Murray and McDonald, hopefully early in March, and then have some language drafted at some point for action before deadlines, knowing that on March 3rd, probably we will have to act on 384. So if anyone wants to take anything out of 384 to incorporate elsewhere, that's a possibility also. If anyone finds anything in 384 that we think should go forward. Sure.
Thank you. My only question is lines 15 to 20, are we just, or 15 to 19, actually, are we just?
Is that on
This
673?
is 673, about the form, which is kind of, is that, do you need that or not really? But that's a whole new thing.
Question for the department,
Yeah.
actually. So that's, I had a follow-up question about what was already reported to the department and what's, no, yes, I understand that. But with regard to protected class violations, that data obviously goes to the office, or those investigations go to the office.
Here comes the attorney.
Yeah, I'm
Right.
curious what type of data is already there, the bill on, as Rep. Paul also asking, like, what are we reporting on when do we do this already or not, with regard to West 15 through next.
We don't get the reporting of any protected class. I can refer this committee to the bulletin report that the department.
I owe everybody $1. So the department does not receive information about protected classes. I will refer this committee to the bullying report that the department collects every year. We report out on that every November. It is on our website. And I think the discussion was more about what is addressed in lines 25 and 26, the aggregate data organized by school. I think there was some discussion about knowing more, just kind of a drill down on what this data represents, because the department is getting it at such a high level. And so I know that there was some discussion about that in November, and we can certainly go back and look at that discussion in more depth. But I think a great place to start is looking at our website and looking at the bullying report, and I can provide that to this committee if you were interested in that.
Right. Representative Balboni?
Yeah, so I have the report up, and it doesn't, in terms of what Attorney Fenton said, it doesn't say protected classes, but it will tell you incidents based on gender, sexual orientation, race, color, or national origin, disability, or physical characteristics. Those are categories already there. So I think it's true. What it says is they're there, but they're there for the entire state. And this is asking for, to break it down more per district, yeah.
Rosemary?
Thank you, Mr. Chair. And I guess my question would be, when we're talking about making informed decisions about what's happening in our, in our districts and spotting patterns early to be able to respond to incidences, would that be, to drill down to the district level, would that be an effective tool to be able to help spot patterns or behaviors that are happening towards individuals based on race, gender, sexuality, you name it?
I'm just concerned about privacy issues and identification of students in some districts. I'm thinking of a case that I know of that it might have been easy to identify the victims involved.
With all due respect, Mr. Chair, I know that we already have I think it's a rule or in place around suppressions, so obviously that would still be in effect, correct?
It could be if you put it into the statute, yeah.
So I guess that's my question. Sorry.
Sorry. I share Representative Cordelli's concerns about privacy because if you're looking at the numbers just statewide in those particular groups, they're very small. So you're looking even at, if I'm looking at sexual orientation here, there's 10, there's, so you're talking about a lot of small numbers here. And I honestly kind of think it's a district or a school board, looking at their own individual districts rather than having this done statewide because you're looking at so small numbers. And I do share those concerns about student privacy.
Rosa Freeman?
Thank you, Mr. Chair, and I'm sorry I missed that part of the conversation because that was a point I was going to bring up, is that I was also concerned about data being easily identified, especially in the smaller districts. But I think also, and I'll ask the attorney this, any time there's an instance of a crime against a protected class, aren't the districts already, help me with the wording, I know the word, aren't they mandated to be court reporters? Are they not mandated to report those if they suspect that it is a hate crime or a crime against a protected class?
They should be reporting that to the Attorney General's office, Office of Civil Rights, or the Human Rights Commission, yes. And we've had instances of that.
Anything further in the research you've been doing, Attorney Fenton?
No, I wish I had something brilliant to share, but I'm just reviewing our annual report.
Is there anything further? It's 2:20. We've been through the 3 bills and have some assignments handed out and some time frames for moving forward. Is there anything further for discussion today on these bullying bills? Great. Seeing none. Thank you very much. I think it's been productive, and I think we can get something accomplished this year. And we will reconvene in about 10 minutes for our first hearing of the afternoon. which is House Bill 709, allowing parents and guardians to admit their children into any school district where they pay any property or school district taxes. And I do not see any of the sponsors here at the moment. Would Representative Freeman, would you be so kind as to introduce the bill to us? He's adding that to the notes.
Good afternoon, Mr. Chair and members of the House Education, Policy, and Administration. I'm here today to introduce House Bill 709, which has a fiscal note. This is an act that would allow parents or guardians to admit their children into any school district where they pay any property or school district taxes. Being as I am not the prime sponsor or even a co-sponsor on this bill, I cannot speak to the merits or the demerits of this bill, but am merely here to introduce it.
Thank you very much. I take it we have no questions for Representative Freeman. Yes,
Mr. Chair, did we ever get an updated fiscal note on this?
not that I'm aware of.
Okay.
It's not uncommon. Does anyone have any questions about the bill? Yeah, I know, right? Seeing none, I guess we'll end the hearing on this bill. I'm sure we'll, yes. No? Go ahead.
Thank you, Mr. Chair. So I'm just curious, when you pay, who pays school district taxes if you're not, just the difference between property tax and school district taxes? How is that differentiated? I'm just trying to think. So I pay my property tax and my school district tax is in there, isn't it, or not?
Yeah.
Okay.
Right.
If my kids don't, wait a minute. So if I don't live in the town, do I still pay school district tax? I guess that's my question. If you don't live in the town, you pay property tax if you own property, but do you pay a different school district tax?
Not sure, but
Thank you.
we,
Can I say?
Yep.
I was just assuming that if someone owns like another home or something, that's what this means. So they're paying property tax. I would imagine it also includes a school tax. It's part of the whole, your bill, right?
That's why I was wondering why it was,
Yeah,
they both mentioned and, you know what I mean, not.
or,
right. Yes, I see what you're saying. Yeah. Right. I don't know if they were trying to make a point that paying the school. Yeah.
So I have a question. Sorry, did that jump you? Would this also apply, like, say you own a business in another town? You're paying property taxes on the business, but you're living in another town. So yeah, that's my question.
okay, well, we don't have any answers today, so we'll, yes. Oh, yes, I'm sorry. Oh, yep. So we won't close the hearing on 709. And we'll welcome Barrett Christina.
Thank you again, Chairman Cordelli. I will be brief, and I may have handed in my card too early, actually. I don't have specific. We are opposed to House Bill 709. I have questions more than anything else. Can the individual who pays property or school district taxes be an out-of-state resident? Can it be somebody from Massachusetts who would then be allowed to send their child to a New Hampshire school? If they own property in more than 2 locations in New Hampshire, does the child get to switch school throughout the year for perhaps non-academic purposes? I'm going to go to this high school because they've got a really good hockey team, but I'm going to go to that high school because they've got a really good basketball team. Does it apply to what I'll call residential property only, or does this also encompass owning commercial property in a particular town? I may have a home in Concord, but my commercial property that I own is in Bow. Is that enough to allow me to attend the school there? We have concerns about if residency for school attendance purposes is broadened to paying taxes or school taxes or property taxes. What else will this open the door to? Will that individual or that family be allowed to vote at annual meeting? Will they be allowed to submit petition warrant articles? And going back to my first question about if it's an out-of-state resident, somebody who lives in Massachusetts but also owns a home here, does that person qualify for in-state tuition to the university system, to UNH or Plymouth State or Keene or whatnot? And also, I think there's an unforeseen aspect of this bill. We know currently that it says the child attends the school where one of the parents resides. This removes the residency aspect. And I guess it doesn't. It says or where's the person. So never mind on that aspect. So those are the questions NHSBA has. One last aspect, I did a quick word search. The word residency appears in New Hampshire statutes, I believe 63 times. Some of them are about additional grant programs. You have to be a resident of the state. It doesn't talk about anything about paying taxes or anything like that. So, there's some aspects in current law that speak about being a resident of the state or a resident of a town. And with that, I'll close my comments and happy to answer any questions.
Any questions? See none. Thank you very much.
Thank you.
And now I can close the hearing on House Bill 709, and we have a little bit of time until our last bill of the day.
All right, we're going to open the hearing on House Bill 741 FN, allowing parents to send their children to any school district they choose. And I welcome the prime sponsor, Representative Cordelli.
Thank you, Chairman Noble. Thank you, fellow committee members. For the record, Glenn Cordelli, representing Tufton Borough, Wolfboro, and Ossipee in the beautiful Lakes region. And it's my pleasure to present House Bill 741. Excuse me. I believe in education freedom, and that includes public schools. This bill expands our current open enrollment statutes to say that all schools are open enrollment schools, that a public school student can attend the public school of their choice, whether it is in the same district or not. Let's walk you through the bill, if I might. On page 1, it starts with the compulsory attendance statutes, and it eliminates on line 4 the requirement that the child is assigned to their resident school district. On further down on that first page, it eliminates much of the language about school attendance and residency and residency disputes, which is not necessary in this legislation. On page 2, there are several definition changes, and this is all in the open enrollment statutes that are on the books now. So there is a definition change to open enrollment public school on lines 16 and 17. There's just an update of the federal legislation to Every Student Succeeds Act. Then in section 6, starting on line 21, the bill states that each district shall be an open enrollment school, and that there is to be a policy to allow students to transfer within district from one district to another in the state, or in any state where we have an interstate compact that does not require non-resident pupils to pay application fees. That's in lines 22 to 26. Down further on lines 30 to 36, it requires each district to post capacity information. Capacity information for each school in the district, each grade level, and vacancies in each individual school on the first of the month, each month, so that so parents looking to possibly transfer to another school has information about that school. Each school district will also report that annually to the Commissioner of Education, and the Commissioner shall publish that information on the state website. On page 3, midway down, starting on line 17, we're almost 7. Very important. It lists the 4 reasons that a district may deny a transfer application. Only these 4 reasons, pretty much behavior related. Following that, enrollment 8, it specifies no receiving school or district shall accept or reject an application based upon grade, age levels, pupil needs, academic, aptitude, or athletic achievement. We don't want schools, public schools, out recruiting basketball players or hockey players. Then at the bottom of the page, it addresses transportation, since that I knew would be a question. And neither the sending or receiving district shall be obligated to provide transportation services for a student outside the resident district. But the parent can work to provide transportation to a bus stop on an existing bus route of the receiving school. On page 4, there is a section, Roman 11 and 12 particularly, that is crossed out and is the subject of an amendment, which I'll go over in a second. It's Amendment 0336H. Further down on lines 20 on, it talks about funding. And this is basically the same funding that is in law now, in that the resident district shall provide not less than 80% of the district's average cost per pupil to the receiving district. That's current law for open enrollment. And I'll mention that Senator Waters over in the Senate has Senate Bill 99, which provides open enrollment to go to CTE centers. So you can go to the CTE center of your choice, and the same funding mechanism would apply for a full-time student going to that CTE center. 80% of the funds would follow the student. So, Senator Waters and I are coming at from two different angles. I'm covering regular public schools, and he's covering CTE centers, which I think is important. And on page 6, I'll just mention, page 5. At the bottom, I repeal 2 sections of the current statute, D3 and D4. D3 relates to adoption of open enrollment status by a district. That's part of the current legislation, but is not needed since all schools will be open enrollment schools. And D4 is related to limits on pupil selection. So that is a summary of the bill. I wanted to mention the amendment that is, I hope, before each one of you, which is 0336H. And the top part, Roman 7, is really the key here, in that it addresses children of military personnel, and they shall be given admission preference over a non-resident pupil. And that replaces the current military section, and I think you'll be hearing more testimony about this from another presenter. But that's the amendment, and that encompasses the bill. I also provided you with a letter from the superintendent at Prospect Mountain School, Mr. Broderick, and this talks about the situation that his school is currently in. They are an open enrollment school, and they are having some difficulties with districts who are trying to send, or districts whose students are coming to his district as open enrollment students. But what I wanted to draw your attention to in particular in this letter is the final couple of lines in the last paragraph, and they state public school programs, public school choice programs like open enrollment answer one of the criticisms I often hear of voucher and other choice programs, that such programs take public money out of public education. But open enrollment keeps public dollars in public schools. Public school choice merely introduces an element of competition that encourages our public schools to meet more family needs. And that's from the superintendent at Prospect Mountain. Residency. There are companies, one that I found in particular, verifyresidence.com. You can hire them to go out and check on residents to see if they're actually in the resident school district that they're supposed to be going to. We have had cases around the country where parents have been jailed for using a relative's address to go to a different public school. In 2011, Kelly Williams Bowler spent 9 days in jail after being convicted of a felony for enrolling her teenage daughters in a school using her father's address. She was then pardoned by the then governor of the state. In 2024, a Academy mom said she would never forget the night when she and her 4 kids were leaving home to go out for dinner, and 2 men who had been hired by the school district approached her to verify their residency in the neighborhood. Personally, some of you might know that just under 2 years ago, my grandson was born missing 1/4 of his heart. He spent the first 7 months of his life in pediatric intensive care. The hospital told my daughter, "You have to be within a half an hour of the hospital at all times." She lived an hour away. What was she going to do? She was a special ed teacher. And she, one of her pupils' parents leased a condo 15 minutes from the hospital. It was vacant. And she let them use that for 7 or 8 months, free of charge. That condo that she leased wasn't used because they just leased it to use that address to send one of their children to that local school district. I could tell you other personal stories also, but that I think happens too regularly around the country. And at least 26 states have legislation that criminalizes using the wrong address for school attendance. And let me just mention a few polls on this topic. October 2023, from a group called Yes Every Kid and YouGovernment, showed that 84% of school parents supported K-12 open enrollment. In July 2024, EdChoice polling shows that 73% of school parents supported open enrollment, 69% of Republicans, 81% of Democrats, and 71% of independents. I think that public schools should be open to all students, like public parks, like public libraries. Competition, as the superintendent in Prospect Mountain pointed out, will work to benefit all public schools and all students and provide for greater achievement and success for those students. I believe that open enrollment and public school choice is one answer to the problems that we see with academics in the state, satisfaction of students, student behavioral issues, and many other things. If students can attend the school that meets their needs and in which they're happy, I think the entire system and the state will be better off. Thank you.
Thank you, Representative Cordelli. Any questions? Representative Hall.
Thank you, Madam Chair. I have a question about the parents that were punished for lying about where they lived and whatnot. I mean, were they punished because they broke the law?
Yes.
Okay, thank you.
Any other questions?
I will mention one story about them I read was that she and her children split time between her house and her father's house. And it was her father's house that she used their address for school enrollment in a school near his house.
Any other questions? Oh, Representative Hall.
Thank you again for taking my question. Can you like just take a school district and like picture what this all looks like? I'm you know, they got a few spaces available, or you just, you know,
I think that many, if not most schools, public schools in the state are facing declining enrollment and have capacity. And I believe there are schools that are looking to outside their boundaries to attract students. And this provides them the legal mechanism to do so. I lived in Tufton Borough, and our kids used to go to Moulton Borough for school. They now go to Wolfboro, but there are certainly some areas of Tufton Borough that are closer to Moulton Borough once you get beyond elementary school, closer to Moulton Borough than they are to Wolfboro. If this law if this bill were to become law, would some of those children choose to go to Moulton Borough again? Possibly. I'm not sure. I don't know.
Follow up. Thank you for taking my question. So financially, the local school where the seats are, if those are filled by somebody else, it's not going to be any cost to that town? Yeah, I know you mentioned the 80%, but I mean, is this like
80% from the resident school district would follow the child to the receiving school district,
in the 20%?
would stay with the sending district.
Okay, thank you.
Representative Murray.
Thank you, Madam Chair. Thank you for taking my question. With regard to page 3 of the underlying bill, lines 27 through 37, we're talking about transportation here. Is there any mileage limit, like distance between, in which, you know, could potentially somebody in Coas County enroll their, based on this bill, enroll their student in another district on the southern part of the state? I mean, I guess my question is, I know that there's a conversation about additional costs, but to what end are we talking about distance traveled and how long a student is potentially on a bus, a vehicle?
Neither the sending nor the receiving school district shall be obligated to provide transportation services. I certainly can see a parent, let's say in Carroll County where I am, working in Belknap or Grafton County, and taking their child to a school over closer to where they work and driving them to school. we actually had legislation last term. It was ultimately defeated, but it would have allowed someone working at a school outside of their resident district to enroll their child in that school where they worked.
Follow up.
Madam Chair. So I guess, and then my other question is, should a student or a pupil receive specialized services that require transportation? What-
Special ed services would be the requirement of the resident district, just like with charter schools, and that's on Roman 2, which I neglected to point out on page 4.
Okay. Yes. One final follow-up, if I may, Madam Chair.
Yes.
Okay, thank you. Is there a world in which a student with special needs could be on a bus or a transportation for an hour or 2 hours? Like, I mean, depending.
I would not foresee that.
Representative Balboni?
Thank you, Madam Chair, and thank you for taking my question. On page 2, lines 29 through 35, it's talking about each school district shall determine for each school in the district the capacity of each school in each grade level. And it says the school district shall post the total capacity. Who has the responsibility of determining that capacity? Because capacity can change depending upon the individual needs of a classroom. So how, if you, just from my school board experience, and you're looking at different classroom compositions, you might need a smaller capacity in that class. I mean, capacity could refer to how many kids you can put in the room.
Right.
So
Yes. Well, that's why it would be posted each month, but also talks about each grade level.
So is it your thought that the school will determine how many?
Yes.
So it's completely up to the school to decide?
Yes.
Isn't
It would be similar to the way it's done. We had a bill about unused space and charter schools. And again, the unused space is determined by the school.
follow up, please?
Follow up.
So then the other aspect of that, it says that you're by the first of the month. So if I read this correctly, people would be able to transfer into established classrooms throughout the school year, depending upon the capacity.
Correct.
Representative Murray?
Thank you, Madam Chair. What happens if a student, transfers in to a district and they don't happen to be at the same place in their learning academic year as their previous school? Is there some onus on the district then to provide services to either catch that student up, or if they're completely at a different place as determined by each district because the districts and the school boards approve their curriculums for the year and they look different across districts? How do you ensure that you don't have a student every month walking into a different academic setting where they may be way ahead or way behind?
I think it would be the same as if a student moved into a new school district and enrolled in that new school district during the school year. They would evaluate where they were and accommodate that student. I don't see it any different for an open enrollment student than someone moving into the district.
Madam Chair. But you did say that the census numbers could change potentially monthly, correct? So if a student enrolled 1 month at school A, is there a possibility that they could, in 2 months, 3 months' time, enroll elsewhere?
I would think that if they enrolled, if, for instance, a child from Tuftonboro enrolled in the middle school in Moultonboro, and after a couple of months found that it was not the right fit for them, or there were some other problems there at the school, then they would be free to transfer back to Tuftonboro and go to the Wolfboro Regional School.
Representative Freeman?
Thank you, Madam Chair. I actually have two questions, if you'll indulge me. Thank you, Representative Cordelli, for taking my question. So from what I've gathered from the crux of this bill, this doesn't take away any local control of the districts. Is that correct?
I don't believe so.
Thank you. And my second question is, and to address some of the concerns about people coming and going and coming and going. Right now in the larger cities in New Hampshire, Manchester, and Nashua, don't they deal with very transient populations?
That is my understanding that they do, from talking to people from Manchester.
Thank you.
Representative Hall?
Thank you, Madam Chair. Thank you for taking my question. How does the school district decide who they take? Let's say 10 special needs students want to come to Bow because they've heard the program is good, and maybe and they only have room for 2. How is that decided upon? First come, first
They would take the first 2 applying.
The first come, first served, no matter who the kids are. Oh, sorry, follow up.
Sure.
Okay, so it's a first come, first serve. When the seat's open, they get it.
Right.
And the follow up to that, how does this affect SAU budgets, school district budgets? I mean, can they budget for all these people coming in? 'Cause they don't even know what they're going to cost, right?
Right. Oh, they have children moving in during the school year. I don't, I'm not envisioning, busloads of students moving from, Tuftonboro to Moultonboro. I don't have statistics with me on states that have open enrollment about how many students are involved. But I know that from what I read in Wisconsin, where they have a open enrollment, I think it was 31% of the students were in rural areas.
Thank you.
Any other questions? Representative Balboni?
Thank you, Madam Chair. Thank you for taking my question. Would it be possible for you to share with us your research and the states that have these policies in place so that we would have some type of comparison?
Yes. Sure.
Thank you.
Any other questions? Seeing none, thank you very much. Mary Wilkie.
Good afternoon. Thank you for taking my testimony. I'm Mary Wilkie. I live in Concord. I'm a retired public school teacher, and I oppose this bill. 2 main reasons. The first is at a time when we have such big gaps between rich and poor in our culture, our society, I feel that these open enrollment bills, this one and some of the other ones that have been proposed, tend to favor the haves and disadvantage the have-nots. I heard Senator Lang introduced a similar bill in the Senate and said that these bills are prioritizing what's best for each individual student. And I feel like that's the sentiment behind many of bills like this, as well as some other privatization kinds of bills. But I don't think they really do. I think this bill prioritizes students who qualify for transfers. So students who don't have discipline issues, who haven't been absent a lot, who haven't ever been expelled. Students whose parents can provide the transportation to another district, which tend to be parents who have more means. And then there's the other group who we should also prioritize, and we aren't talking about them. We're talking about giving a certain group of people a privilege, but ignoring the rest. And so if we have, for instance, two students in a district and one transfers to a new district because she wants to take French and her district provides no foreign language because they're a property poor town. And her best friend wants to take French too, but her parents can't afford to get her to provide transportation, or they don't have the time to provide transportation to the other district. Or maybe her parents have substance abuse issues, and that's caused her to be absent a lot. So she doesn't get that opportunity. Well, what are we doing to prioritize her? I feel like we have to prioritize every single child in New Hampshire schools. And the only reason we can prioritize both of those children and make sure they both get foreign language, which is it's not something like, having major theater in their school, some huge theatrical opportunity. It's a basic that we all expect in our high schools. The only way we can prioritize that for both of them is to make sure that the original school district can offer foreign language. And the way we can do that is to make sure that every district has the amount of funding they need to provide the basics that are in our core curriculum, in our adequacy laws. And then and because also as students who have the means and who fit the qualifications leave their district, the students who left behind are the ones whose parents don't have the means to help them do it, or who have disciplinary issues, whatever the issues are. They tend to be more than average in terms of the expense of educating them, and yet more resources are leaving. And so they're going to be left with fewer resources than they had when students started leaving their district. And the second issue is, and I wonder if, when I read on page 4, line 23, saying how the money goes between the two districts, I read it differently than you intended, Representative Cordelli. I thought it says the pupil's resident district shall pay to the receiving district an amount equal to not less than 80% of that district's average cost. I thought it meant the receiving districts. I think it would be good to clarify what you said was you meant it to be the sending district. But assuming that it's the sending district, for instance, Portsmouth Elementary's cost per pupil as of 2024 was $26,000 about. Newcastle's right next door was $44,000. If Portsmouth sends 80% to Newcastle, because per student who leaves Portsmouth to go to Newcastle Elementary, then Portsmouth is giving Newcastle $21,000 a year for those students, while Newcastle taxpayers are paying $44,000 per year, minus whatever's coming from the federal government and the state government. And I know this is the same formula that's already in the law, but the law right now is voluntary, and this makes it involuntary, as I understand it. I don't think Newcastle can say we don't want to participate because this is going to suddenly really change our budget in a way we don't want. So, and just one last thing is, did I lose it? Whoops, I think I left it behind. It was, never mind. I had one more point, but somebody else raised it. So those were my main issues about this bill. Thank you.
Thank you. Any questions? Seeing none, thank you. Melissa Willett.
Good afternoon. Honorable members of the committee, the Department of Defense is grateful for the opportunity to provide comment on the policies reflected in House Bill 741 as it relates to flexible enrollment options for military families with school-aged children. My name is Melissa Willett, and I'm the New England Region Liaison at the United States Department of Defense State Liaison Office, operating under the direction of the Undersecretary of Defense for Personnel and Readiness. We represent the department and establish relationships with state and local leaders on issues currently impacting our service members and their families. Approximately 185,000 U.S. military children move between schools annually. Military families are at a disadvantage when it comes to enrollment options available to their children due to the timing of military-directed moves. Military families move frequently and change school systems upwards of 10 times prior to graduation. In addition to planned permanent change of station moves, military families often experience additional subsequent relocations from temporary to permanent housing due to limited availability of military or community housing at the time of their arrival. Allowing military families to enroll their children in the school district they know they'll permanently reside in will help to facilitate their uninterrupted educational progress and smooth integration into their new communities and relieve undue stress during their transition between military duty assignments. With approximately 1,300 active duty service members and 800 active duty children attending school in New Hampshire, this committee has an opportunity to have a highly impactful and positive effect on the educational experiences of military connected children. The Department of Defense is hopeful to discuss options to protect the enrollment options for these families. As such, we have offered an amendment to the current bill, which will not change the general policy, but clarify that military-connected students would have preference over non-resident pupils should their parents be on active duty orders, and clarifying that military-connected students be exempt from school capacity limits. Basically speaking, the amended language would not or would retain current law. So in current law, military connected children have these available options, but it was stricken with House Bill 741. So the amended language that we have provided to the chair would put those families back into the bill. So in closing, we are grateful for the tremendous efforts New Hampshire has historically made to support our military families and service members. We appreciate the opportunity to support the policies reflected in the bill and thank Chairman Cordelli for his willingness to review our proposed amendment. Thank you for taking the time to consider and deliberate on this issue, and at this time, I stand ready to answer any questions you may have.
Thank you. Anybody have any questions? Representative Balboni.
Thank you, Madam Chair, and thank you for taking my question. Forgive me if I'm not as knowledgeable about what currently is provided for children of military families. You're talking about military families moving amongst different locations statewide?
So
And
across the country from one duty station to another. So those PCS moves, the military family may move from San Diego, California to the Portsmouth Naval Shipyard. So they may move to a residence in the state of New Hampshire.
Follow up. So my question is, I'm not understanding how this would change anything, because if you had a military family and they came and they went to Portsmouth and that's where they're residing, and then they go to San Diego. Are you talking about children that are left behind with family members being able to say? Because if the family's moving to San Diego and then they move back, why wouldn't they already be?
So under current New Hampshire law, military families have preference if their parents are active duty service members. So that service member is on orders. That pupil has the ability to enroll in the school district of their choice, no matter their residence, because they may have moved from temporary to permanent housing. So that family can register and enroll their child in the school district that they know they're going to reside in. This bill struck the military connected children out of the statute. So we're trying to get it. We are respectively asking the committee to include the military family so that those children have access to open enrollment policies and retain those open enrollment options, which are currently in New Hampshire statute.
So just to be perfectly clear, what you're saying is the original bill took away that ability and
Correct.
You're just advocating for it to remain the
correct.
same.
Correct.
Okay, thank you.
Representative Freeman.
Thank you, Madam Chair, and thank you for coming in front of us. And I don't know if you were aware of the amendment that Representative Cordelli had put in, which actually added the language right back into this bill.
Yep, we worked with the chairman on that.
Thank you.
Thank you.
Any other questions? Representative Hall.
Chair, and thank you for taking my question. I'm just curious on, let's say when you said that they are exempt even if the school has reached capacity limits, What happens, I mean, are there fire codes that say that a school district can only have so many students? I mean, maybe not. I'm just curious. Like-
I'm unaware of those specifics, but broadly speaking, the roughly 17 states that have enacted some sort of open enrollment for military connected children have had that capacity limit revised so that those particular families can enroll their child due to those military service orders.
Thank you.
Any other questions? Seeing none, thank you.
Thank you.
Barrett Christina.
Thank you, Madam Vice Chair. Good afternoon, members of the committee. Barrett Christina, New Hampshire School Boards Association. Excuse me. We are opposed to House Bill 741. I will follow up with written comments as this is a similar bill to Senate Bill 101, which was heard in Senate Education a few weeks ago, and I wrote written comments to that committee as well, too, so I can basically copy and paste. I think I've got about 5 or 6 points that I want to identify. First, create, and I'll try not to read exactly from my notes here. Creating an open enrollment system, a statewide open enrollment system would interfere with dozens, if not scores, of existing tuition agreements that exist across the state that have been duly bargained, negotiated, and agreed to by untold number of local school districts and school boards. More importantly, many of these tuition agreements have a requirement that the sending school district send a certain number or a certain percentage of students to the receiving school district so the receiving school district can properly budget and they know how many kids they're going to be getting in any given year. So the bill is silent on what we would do with those existing tuition contracts, whether or not they expire, whether or not the state law would supersede them, but it would create havoc for the dozens, if not scores, of school districts that are already parties to tuition contracts and tuition agreements statewide. Page 2, lines 28 through 32 talks about each month principal or somebody's going to have to identify what the capacity of each school and each grade level is. And the capacity of each grade level, the number of vacancies in each individual school. NHSBA finds it paradoxical that many bills across both chambers of the New Hampshire General Court last session and this session complain about school districts having too many administrators. I can count to dozens of bills over the last number of years that just put what I'll call busy work into the hands of school administrators rather than focusing on curriculum instruction or assessment. NHSBA would rather those administrators had time to focus on reading scores and writing scores and math scores and not filling out reports or filling out data to send to the Department of Education that has nothing to do with curriculum instruction or assessment. Third, page 2, line 30 speaks to districts having to post the quote total capacity, close quote, of each individual school. NHSBA asks the total capacity of what? Is it student enrollment? Is it empty seats? Is it a school district's fiscal capacity? We're coming up on annual meetings. We know different districts have different fiscal capacities. Staffing capacity, transportation capacity. The bill is not clear and does not accurately reflect the numerous capacities, in quotation marks, that school districts have to encounter. Fourth, related to a school district's fiscal capacities, the bill House Bill 741 does not adequately consider school district budgeting. As I talked about with the tuition contracts, a school district or a school board has to know roughly how many kids they're going to have in any given year so they can budget accordingly. My example, if this bill were to go through, a school district would potentially have to budget at 100% of the various capacities I mentioned preceding. A school district with a student enrollment of 500 students, but with a quote unquote capacity of 700 students, would have to budget for those 700 students. This would not be fiscally prudent and would play havoc with local tax rates if we had kids coming and going at will, if you will, without a clear concept or a clear notion of how many kids are going to be in a school district in any given year. Also related to, I'll just call it the enrollment capacity or the capacity per classroom. what happens if non-resident students fill that capacity and then resident students move into that school district? Are they given first choice? Is the school district going to have to hire another teacher? Is there going to have to build another wing, more paraprofessionals? It sort of gets to the total scope of this relative to how districts are going to budget in any given school year and what we mean by quote unquote capacity. But the SIL bill is silent on these particular matters. Last, somebody had mentioned a great number of transient students in some of our communities. Students who, through unfortunate circumstances, are required to move to a district, from district to district multiple times a year. How is this? Is that a true reflection of the student enrollment capacity that is listed throughout the bill? Further, we'd also posit that having a significant number of transient students is not a true reflection of the district's sort of quote unquote capacity. Last, I'll leave you with, there's another bill relative to is House Bill 771, Representative Peternell's bill, was heard in the Ed Funding Committee a week or so ago, maybe 2 weeks ago at this point, also tweaking RSA 194D. I should let you know that Representative Chairman Cordelli mentioned the Prospect Mountain School District, and he received an email or a letter from the superintendent of that school district. There is ongoing litigation between Prospect Mountain and another school district relative to the interpretation of the current open enrollment bill, the current open enrollment statute, if you will. To my knowledge, that's still pending before the New Hampshire Supreme Court. So there's issues over who has the obligation to pay without prior notice to a school district. What happens if a parent unilaterally changes placements relative to special education, transportation, so on and so forth. So it's a complicated matter. I raised some issues and some concerns NHSBA has with the bill. If you'd like, I can follow up with written testimony, but that will conclude my testimony. I'm happy to answer any questions that the committee may have.
Thank you. Representative McDonald.
Thank you, Chairwoman Noble, and thank you again for your testimony. Does your organization have any connections to other states that have done this and have been able to do it successfully?
Thank you for the question, Representative. That was mentioned in Senate Ed as well, too, that a number of states have these open enrollment provisions. I know one number was floated in Senate Ed. I don't know what it is. I do have connections where I can do some research and find that out. How quickly I can get that, how accurate, how in totality. NHSBA does not have a lot of capacity with only 4 staff members, so I can certainly try and do some research. I'm sure Representative Cordelli, I know he's very thorough in his research as well, too. I can see what I can find out and pass it along to the committee, though. Thank you.
Thank you. Representative Murray.
Thank you, Madam Chair. Thank you for taking my question. I have 2, if I may, Madam Chair.
Sure.
Okay, thank you. First question is with regard to the hiring process. Do you have any concerns that that process could become hurried or rushed in the event that school census numbers would change or fluctuate on a month-to-month basis?
Thank for the question, Representative. I hadn't contemplated or considered that, and I forget if the bill does the bill have a deadline as to when you have to quote unquote transfer, or is it at any time? I mean, if it's at any time, it would potentially be problematic or cause a district with staffing with a local issue. I mean, we have not a shortage of certified teachers per se, but, once you get into May, June, July, and August, it's hard to find teachers, especially with specific, expertise, if you will. Math teachers, science teachers are hard to come by. The other aspect, too, is depending on the needs of that individual child. I don't know any school district in New Hampshire that is at quote unquote full capacity with the number of paraprofessionals that they need. So, a kid moves in, changes school, let's say over Christmas break, and they show up on January 2nd, but that kid's IEP says they need a one-on-one or supportive help in a school in their classroom. That could be a significant challenge.
And then my second question, thank you, Madam Chair, is with regard to something that I had just been thinking as we were talking here. Could this bill unintentionally impact matters of like child and family law, like custody agreements, like who has jurisdiction to enroll their child in in a place?
Yeah, thank you for the question, Representative. I have limited knowledge of sort of what I'll just call the divorce proceedings and the parenting plans. There is a provision currently in the in the current residency statute, RSA 193:12, that does say that if the parents are divorced and live in different towns, that the parents can choose what school the child will attend. And I mean, I don't know, this is anecdotally, I don't never practice divorce law. I think that the parenting plans will generally say that, mom has the child will live with mom and attend the school where mom lives, or the child will live with mom and attend where mom lives, or the child will live with dad and attend school where the dad lives. However, I know the parties are at least free to determine themselves where the child's going to attend, but if I think that's more of a divorce law issue than it is necessarily an open enrollment or a school law issue. Yeah. I don't want to say anything that would be inaccurate. Yeah.
Any other questions? Seeing none, thank you.
Thank you.
David Trumbull.
Thank you, Madam Chairwoman. My name is David, and committee members, hello. My name is David Trumbull. I'm from the town of Ware. I have concerns about this bill, and there's, I guess, three of them. The first is I think that it would exacerbate the inequities in New Hampshire's system, as has been mentioned. Open enrollment as a concept is based on the idea of choice, that every child should have a choice. But that's only going to be fair if every child has the opportunity to get an adequate education in their home school. The first necessary step in order to have a fair open enrollment program would be that every home school provides every child with an adequate education. One of the states that does open enrollment is Michigan. And according to the latest statistics from the U.S. Census, they provide, as a state, 55% of the funds for their schools. New Hampshire, by that same data, is 27.9%. So they're providing twice as much as we do. So in Michigan, every single school is reasonably well funded, so you don't have the issue of haves and have-nots. So you wouldn't have people wanting to flee a school because it's so massively underfunded, but that would certainly happen in New Hampshire. If you look at New Hampshire, the unique feature that makes up our school system is the heavy reliance on the property taxes. It's the heaviest in any state in America. We are the lowest spending state of all 50 states. We give 27% of the funds to the schools from the state. We're at the bottom. We are the last state that's ready for an open enrollment policy. Even if you think it's a good idea, step one would be to fund the public schools adequately first. Once that happens, then you could say, okay, maybe open enrollment would work. But as long as you have gross inequities, it won't work. Just look at some schools in this state can only spend $14,000 a pupil. The average is $21,000. Some spend $30,000 or $40,000. Why is that? Because their local property tax base isn't high enough. What's the result of that educationally? Look at the proficiency scores at the DOE. Newport, less than 10% of the kids are at category 3 or 4 out of 1, 2, 3, and 4 of proficiency. Charlestown, 10%. Claremont, 18%. Ware, 22%. Statewide average is just a little short of 40%. Bedford, 69%. Hopkinton, 61%. Concord, 54%. Sunapee, I don't have it, but I know it's quite high. The point being that children who live in Newport could easily say, Sunapee's next door, I want to go there because they have a tax base that can support a good school. This would be exacerbating the differences. The low-income family in Newport who can't transport their child all the way over to Sunapee but can easily take their child to a bus in Newport, they're not going to be eligible to participate in this. Children who have discipline problems are not going to be eligible to participate in this. We know, the studies show that children with disabilities are expelled, have discipline issues at schools, I should say, at a much higher rate, 2, 3, 4, 5 times higher than children without disabilities. children of color for the same behaviors, e.g., using their cell phone in class, are disciplined at a much higher rate, 5 to 10 times more than white children. So what's going to happen is you're going to have some children who cannot participate in this program because the reasons why you can deny somebody is they have discipline problems. People who can't access it because of transportation. You're going to, and then 80% of the money for the children who do leave, those whose parents can afford to go over to the town that spends a lot of money on their schools, 80% of the money goes with them. So now Newport has even less money to educate the children who are left behind. If the state of New Hampshire did its job and funded every school adequately, then you could see a case for open enrollment, but you wouldn't see as many people wanting to flee that Newport school as you would right now. Until you adequately do job one, it's premature for this one. My second concern is that this tramples all over local control. A question was asked, would it reduce local control? And the answer was no. It dramatically reduces local control. Right now, you have a voluntary open enrollment system in New Hampshire. That's the perfect solution in a state that doesn't have state funding for the schools. Voluntary. If a town wants to open its doors to more students, they can do that in the present system. This bill reduces and takes away local control and forces that on everybody. Also, has been mentioned, the issue of budgeting. Every school district goes through their budgets, and they're pages and pages. How would you budget for this? You have to budget by year, but every month you have to send in capacity differences. There's no way that you could properly budget for that. Either the school board is going to over budget and think, oh, what if we get a whole bunch of new people who come in, students, and they don't come in, but you're still taxing at that rate. Your taxpayers are going to be irate. That's not fair to them to have to be taxed at that rate, or they're going to under budget. The problem with that is that most schools, small schools, will leave a couple of slots open because they know some people are going to move in during the year. But now, if they under budget, they won't have the money for those. Right now, they have a system. They can budget for what they can budget for. They know they leave a couple spots open. This bill would trample all over the local people, the local school budgets trying to manage what they're doing. The other question that comes up is, what about a fifth grader who transfers in to another school and then says, I like it over there in that middle school, but the next year that district has people who move into the town and fill up all their slots. So now does that student have a right to go there for 6th, 7th, and 8th grade? Or is it an annual thing if you're not the resident of the school? So this isn't really contemplated in any of the things. Just lastly, to finish up, there was a question about people who get arrested for using the wrong address. I mean, the reason why somebody would do that in New Hampshire is because they know that that address has a really strong school system. But if you're not living there, you're not paying, your family nuclear unit is not living there, you're not paying the property taxes to support that really good school system. That's the reason why. It's because we don't adequately fund our schools. Then the other question was about declining enrollments. There's some schools that want more students. Those schools can do that right now under current law because you have voluntary open enrollment. If a school wants to do it, they can do it now. This bill forces every school to do it, and it's going to create chaos in our school system. And most importantly, it will just exacerbate the inequalities. That's the greatest problem in New Hampshire's education, is the inequalities between the haves and the have-not school systems. Until you solve that, that's the first step. Then you can consider open enrollment. At least that's what would be my opinion. Thank you.
Thank you. Any questions? Representative Murray.
Thank you, Madam Chair. And thank you for taking my question. So my question to you would be, I think based on what you were saying, would it be accurate to say that there's a concern regarding further segregating either through socioeconomic status or historically marginalized communities, that would increase based if this were to move forward in that way?
Absolutely, because in a town, every town has different socioeconomic statuses and students who have disabilities and those who don't. But people would be, those who have more money would be able to access the driving and the transportation, and those whose children have not been disciplined would be able to access. So the people who would get left behind would be low-income families and students who have discipline issues. So you're going to even exacerbate even more the haves and the have-nots.
Any other questions? Representative McDonald.
Thank you, Madam Chair, and welcome back to education, Mr.
Hello.
Trumbull.
Nice to see you.
The sponsor mentioned that we have no reason to expect a busload of students, or at least he doesn't expect that. And if that's the case, we're talking a relatively small number of students. and you use the word exasperate. So how would a small number of students taking advantage of this cause chaos and exasperate the system?
If it's just a small number and the other school was willing to take a few, they could do that right now. So if the town that has a great well-funded school system says, oh, we could handle 5 more, and they were willing to do that, they could do that right now. But by mandating it, you force every school every month to come up with a number of slots that they're going to have in every classroom. So there's no guarantee that it wouldn't be a significant number. You could easily see parents in a town that has a struggling, barely functioning school system say, this is my ticket out. And so they could very easily try and access this system. And I'm not saying those kids don't deserve a great education. My point is that every child deserves a great education. And if we only funded them in the first place where they were, they wouldn't say, I want to get out of my school system.
Thanks, Mr. Trimble.
Yeah.
Any other questions? Seeing none, thank you.
Thank you.
Deborah House.
Okay, good afternoon, Chairman Noble and members of the House Education Policy Committee. Good to be with you this afternoon. My name is Deborah Howes. I am president of the American Federation of Teachers, New Hampshire. I'm here to speak against House Bill 741. We oppose this bill because it is a mandate. We would like to be able to support this bill, but as a previous speaker said, we cannot support this bill until all of our students in the Granite State have the opportunity of a great, robust public education in every single local neighborhood public school in every school district. Since the state is not meeting its constitutional obligation to fund that, and that opportunity varies widely from one district to another, because they are currently funded 70% with local property tax money, we cannot support open enrollment. If we can fix that first problem, we can have this conversation maybe in a few years. Okay, but this is a mandate. It does require local districts to adopt an open enrollment policy and to allow for transfers between districts unless there is not capacity or the student has a discipline issue or an absentee issue. That means that the sending district has to agree to send and the receiving district has to agree to receive. Currently that is something that they can work out considering the best interest of that particular student, but also the needs of the receiving school when they look at the other students in the classroom that will receive that student, the staff level they have, whether they can meet the academic and social behavioral needs of the student coming in, as well as all the other students in the classroom. So they can balance all of those things out. And if it works out, they usually will agree. But they don't have to. This law, if this bill, if it passes, would make it a have to. So yes, it is stepping on local control. Let's see. So when I look at this, I think about how it would play out in my school district. I live in Hudson. And we are one of the lower funded school districts in the area. We are a town that struggles with property taxes. We don't have a big tax base. We provide as good an education as we can with that tax base. We don't have a lot of extras. We go through our deliberative session every year and have a list of, well, we can afford this, but that's going to have to wait. That's going to have to wait. We pinch every penny till it screams. So if this passed, I could see there would be a number of families in Hudson who would love to be able to transfer their students to Wyndham next door. Because Wyndham and their taxpayers have invested in their school system and been able to because they have a tax base that is better able to support lower class sizes, investing in more teachers and paraprofessionals, investing in a wider variety of programs at their middle and high schools, particularly the middle and high school. Okay, I love our high school, I love our middle school, but they offer more in Wyndham. And I know that many of our families in Hudson would love to be able to just cross that line. Not all of them would be able to, because we have students who have discipline issues. We have students who have absenteeism issues. We have students with special needs who maybe would try and go next door. We'd still have to bear the cost of providing services for them. We would still have to keep the students with absentee issues, with behavior issues, discipline issues. And so I'm not sure our taxpayers would see any relief. Of course, we'd have to send 80% of the money. We wouldn't have any chance to negotiate that either. That's another imposition on local control, because there'd be no negotiation between us and Wyndham. And I don't know that the taxpayers of Wyndham would want all of the students that would want to come either. I understand the prime sponsor has said that the local school district is allowed to define capacity. That's not made clear in this bill, because it just says identify capacity. So you could also read it to, as is outlined in the minimum standards for public schools that were just adopted, which is just a flat out number of certified adults to students in the grade level across the building. So that is unclear from the bill. Anyway, Wyndham has invested in their schools at a certain rate, and I don't know if they necessarily want an influx of students either. I've been told from, professionals who work in the Wyndham school system that they're not allowed to tuition their own students in, their own children. So I don't know they want a lot of people coming from another town. We oppose this bill. That's also not good, because you can't plan for the students who are going to be in your class if you don't know who they're going to be from month to month. You have a hard time making sure you have the people to support their academic needs, the resources and curriculum to support their academic needs. It's bad from so many perspectives. We would love to be able to support it, but you've got to fix it so that every single school is able to offer the same robust level of public education. Then we can talk about, helping with geographic transfers to better meet whatever families' needs are. And that's my testimony. Thank you.
Thank you. Any questions? Representative Murray.
Yeah.
Thank you, Madam Chair, and thank you for taking my question. I have a question about whether or not, through survey data you may have compiled over the years, do you have any idea of how many families might experience an undue hardship, maybe having access to no car, one car, multi-working parents, and how they would navigate transportation in this circumstance?
I don't have any survey data. I know in my years of teaching, we had many families at my school in Nashua who would have one car or no car in the family. It was a struggle to get them to arrange for rides to get families to parent teacher night. I worked in elementary school, so we usually have high attendance at parent teacher nights. They want to come see the projects. They want to come meet the teacher. They want to come enjoy a snack. It's a good time usually, and we would feed the family's dinner. That was always part of our parent teacher night. There'd be a dinner in the cafeteria and all the displays and projects, and the kids would come and show off the classroom and the projects. So it was a good, positive things, as well as talking about how your kid is doing and that part of it. But we would have our homeschool coordinator having to work with people she knew that lived in the neighborhood to get rides for some of our families, because this one's car broke down, that one didn't have a car. Luckily I lived in Nashua. Some of them would live close enough to a bus line they could come, but the last few years buses don't run that late. It's a problem. I don't have hard data, I can't tell you what percentage. I just know it was something that would affect a number of families every year, and was always a chore that the homeschool coordinator had to arrange so that the families could come participate in their child's education and meet and talk with us, which they really want to do, and we really want to talk with them.
Follow up.
Can you imagine, or would you envision that this might not just be an urban issue. It could also be a rural issue for rural access to transportation.
Oh, it's even worse if you're rural, because then you don't have the fallback of a bus. There's not that option. And you might not have neighbors as close by that could maybe give you a lift if you just, walk down the street. Yeah.
Any other questions? Representative Hall.
Thank you for taking my
Yep.
question. Do you envision, when I'm thinking about the Hudson Wyndham
Yeah.
situation, that a school district could contract with teachers? They contracted their staff, and all of a sudden you have these people leaving. Now they've got staff that they've hired, that they're contracted
Yes.
with, but they don't need.
Well, that's it. You might have way more staff than you need, and you've got them for the year.
Right.
And then next door, they might not have enough staff, or if they're allowed to say, well, we're at capacity. How does that work when you're going month to month? And that would be very difficult. And then again, you don't know who's going to be in your classroom from month to month. How do you meet the learning needs of those students? So all of those things are going through my head.
Thank you.
Yes.
Any other questions? Seeing none, thank you. Thanks. Sarah Scott.
Thank you, Madam Chair and members of the committee for the opportunity to testify here today. My name is Sarah Scott, and I'm with Americans for Prosperity here in New Hampshire. I think a lot of the points have already been covered, so I'll try to keep this brief, but I'm here today in support of this legislation. And I think really this boils down to HB 741 is a simple and yet transformative idea that families have different needs and they know what's best for their family. While many families are finding success in their local public school, there are other families that are experiencing certain needs that require them to look outside of that district. We've talked a lot about academics, and I think the hearing in the Senate talked a lot about academics also, but there are a number of situations that families might be facing that would require them to look at programs like this. So for example, childcare is a huge issue in this state. It's something that a number of young families are facing here, and allowing a student to go to another district may be their only solution for getting childcare. So a lot of families are relying on parents or family friends to go and watch their children after school. If they're able to go and look at another district where that family is, this might be the only real solution for their family in terms of childcare. You have instances of families that the parents work outside of the district, could be a teacher or somebody else, that 25-minute drive to school might be the 25 minutes they get to spend with their child every morning. That really leads to a lot of valuable family time that because of work schedules, they just don't get any other way. So there could be a number of situations with family illness. I know my family for a long time took care of a grandmother that was not doing well. And being able to look at other districts and find those opportunities there might be the way that families are finding a solution for aging family members. So I think there are a number of situations in which this type of legislation would provide huge benefits to the family. There are a number of states that have passed similar bills already. I believe the number is over 20. I've seen conflicting reports over exactly how many, but I believe it's 25. Have policies like this and have addressed a number of the problems that have been brought up today. So I don't think this is an entirely new piece of legislation. I think many states have figured out how to make this operate efficiently. And overall, I would just say I think this creates a great opportunity for a lot of families here, and hope you pass this legislation. Thanks.
Thank you. Any questions? Seeing none, thank you very much. And with that, we'll close the hearing on HB 741.